Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
I didn't ask you to interrupt me. Dahil hihiyang like I'm worried.
Well, it is good to be back. Welcome. I would say good morning. It's almost good afternoon. It's almost good afternoon. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you so much for joining me. Big shout out to all the JHACH defense team. Hope you're all on board today with your pens and papers ready. Great to have you all here. And thank you, by the way, for all the views. I saw views across all the live stream, so I can only anticipate that it was you going over every little bit. Welcome. I also have to give a huge shout out, by the way. Huge shout out. Please make this work. Please. No, it's not working. Change my IP address. That's the problem. All right, we'll do this one that way. Oh, there it is. Okay. We're good. Okay. On. Why is it not working? Why is it not going live there? I have to give a huge shout out to Sample User. Sample User, who says this live stream is the best. Okay, so let's...
Because he's the guy.
Because he's the guy. Hang on one second. One second. We're going to figure this out. What did I do wrong in this life or a preceding one? Oh, there we go. Aha! I fixed it. There's Sample User. No. Shout out to Kim R. Kim, congratulations. You not only came in clutch first in chat today, but you fixed my internet, which was important. We had some issues with the internet. It actually started in May when I got fiber internet. And I've been fighting this issue since then, since day one. And I finally went through all the tech support help and everything, tried to get this. It's just a small thing. I'm just not able to access the internet using my computer. So it's not like the internet's down. It's just I'm not able to access it. So I thought, maybe it would be good if they fixed that since I paid them for it. Turns out after many hours on the phone over the weekend.
I'm not a cat.
And even having two techs, the tech and like a supervisor here on scene, their synopsis was, we don't know what the problem is. We recognize it appears to be in our equipment. We recommend you buy your own equipment instead of using ours. And good luck. That was what they ended up with. Good luck. So it's like all internet companies are the same. It's like they learn from the school of JHACH when it comes to customer service. Anyway. All right, Kim R., thank you very much for being first in chat. You have won the internet. I see Dr. SB, so glad to see the internet's fixed. Love to watch. Yes, we're going to get some fun stuff today. Victoria Bowley says...
when are we going to break for lunch?
When are we going to break for lunch? We're going to break for lunch in just a minute. There was supposed to be a hearing with Judge Carroll this morning. Does anyone know how it went? He was supposed to be on Zoom. Okay, here's what I know. No hearing today. This is what I'm hearing. I was checking in with Dr. Joe. He was doing some checking for me as well. No hearing today. What we do expect to see today is filings from the plaintiff in response to the juror number 1 motion. So we're looking for a response. No hearing today that I know of. Mimi NC, welcome to the gallery. Thank you very much. Love to see that courthouse change color. I think I missed some super chats or some people who were first in. Let's see, we had Dr. SB. Was there anyone else who... There was like a member message, and I think I missed it. I'm so sorry. I scroll up, and it's not there. Oh, wait. There it is. Very last. Oh, on the very, very top. Gigi. Woohoo. 1 month member. Love RA. Thank you so much, Gigi. I just about missed this one. Had one more person typed in chat, it would be gone forever. but I was able to snag it there at the last minute. Thank you very much, Kim R. I'll be yellow when I get my courthouse back. Awesome, Kim. You're putting in the work today. No courthouse, and you're fixing the internet. It's amazing. I will. We have a lot of things to talk about, other than the fact that my internet was broken, and now it appears to be somewhat fixed, which is good. I'm back in my happy place. It's not fixed. It's exactly as broken as it was before they broke it further and then had to.
There's a lawsuit.
Yes, I think it's going to be class action lawsuit here in a little bit, because sorry, you got me going on this tirade. My internet provider's very own webpage and the hardware manufacturer's very own webpage for the equipment that my internet provider installs in my house. If you go to their community support page, it's full of complaints with my exact issue. And every time you call, they're like, "Oh, we've never heard of this before." I'm like, "Really?" Because here's 15 articles when I do a search on your tech support page. 15 articles of people who have the same problem. And guess what? Every single one ends with, "We don't know what the problem is. We can't fix it. Good luck." Anyway, Lauren Farmer, so excited to spend my birthday with you and chat today. Lauren, that reminds me, today is your special day, apparently. So let's see if there's anyone else that needs to be sung to. Let's see. Lauren, we've got Lauren. Is there anyone else who has a birthday today? And before we kick off a little bit of reading, I will tell you what's supposed to happen today. We've got some updates in the Maya trial, the documents. Oh my goodness, the documents. I will say a big shout out to Megan Fox, to Legal Vices. They went over some of these documents already, and did a fairly good job picking out the absurdities in this. And we're going to go over some of those as well. There are new documents filed again today. Not really big stuff. It's small stuff. But we've seen those come out.
Have them send someone with more experience.
Oh, well, next time I'll do that. Let's see, Mrs. Greeners. Let's put Mrs. Greeners on there. We'll sing to her. Okay. Let's see. Me birthday, says Amy. Amy. Let's see. Birthday here, Mary T. We're going to have a lot of names. It's going to be like a multiverse version. MCAT says member for 10 months with pickles, spicy pickles. I have some spicy maple bourbon pickles in the cupboard. I'm waiting to have room in the fridge, but I don't have room in the fridge because there are so many leftovers from Thanksgiving. And speaking of which, I hope your Thanksgiving was absolutely, absolutely wonderful. Oh, look at this. Sharon is on the ball. So we've got Amy. I've got Amy. Lauren. Got Lauren. Fiona W. That's a new one. Fiona W. Mrs. Greener. And Mary T. Okay. All right.
I'm not a cat.
I think we've got it. This might take, oh man, it's either going to take me talking the fastest as I've ever talked, or two verses. We're going to try to fit it all in. Lauren, Miss Greeners, Amy, Mary, and Fiona. La 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 la. Here we go. Everybody in back too. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, Lauren, Screeners, Amy, Mary, and Fiona. Happy birthday to you. I nailed it on the first try. All the names. That is wonderful. To all those who are celebrating a birthday today. Let's see, my birthday was on Thanksgiving. Joey, happy birthday to you. That sounds amazing. Happy birthday to your mom, Nisi, as well. Lots of birthdays to all those that are celebrating birthdays or recently celebrated a birthday. Let's see, Joanne or Joan? I think it's Joan. Lauren, congratulations, Joan, on your birthday as well. To everyone who's celebrating, I hope you had a fantastic or have a fantastic birthday. I did, for all of you, I went out and got a present for myself. Is that how you do it? As my internet was out this morning, I had to run to the store. I ran to Best Buy. I thought Cyber Monday, best time to actually run physically and shop at a store, right? Because everyone else is at home on the internet, which mine wasn't working. So I ran to Best Buy and I had to get a little monitor for a project we have coming up, a parade that I'm live streaming later this week for the town. And I needed a 24-inch monitor, the smallest thing I could get. And they were on sale. And I bought the two that I needed and they came running home. and I was showing them off to my wife, and I realized that I bought the wrong ones. Yeah. So I bought myself 2 presents off for your birthday, and I have to go return them already. I haven't even opened them. But anyway, good stuff, good stuff. All right. We're going to fade out the birthday song, which seems to go forever. Goes forever. All right, let's see. We have, sent an email to me. I read my email once a month, whether or not I need to, but I will check that. Let's see. Yes, our little town is going to do a Christmas parade in the evening. It'll probably interfere with whatever we're live streaming Thursday or Friday. I'm not sure which day it is. Probably should figure that out because it's this week. But we're going to be setting up cameras and live streaming for all those who are not able to go out and watch the parade. Because we have a fair amount of our population in the town is there's an ambulance is advancing in years, and parades in the dark are not the most fun thing for them to attend, although they wish they could at least watch. So we're going to try to provide it for them digitally, and we're putting on a big production that way. Samantha Terry, brand new member, 10 months. 10 months. Look at that. Samantha, thank you very much. Most people wait until December to start returning gifts. I know. I'm going to get a jump start on it. Do a Cyber Monday return. Probably later this afternoon. Because I need to get the deal on the right TVs. No wonder they were so cheap. All right. We have to make up for lost time because we're already halfway through the day, and this is crazy. Plus, it's way too cold to watch at night. Well, we're in North Carolina, so winter in North Carolina. You know it's winter because that's when the dandelions bloom. For everyone else, the dandelions bloom in the middle of summer. That's when ours bloom. So it's winter. Yeah, here's how wintry it is. The family's planning a little trip over the holidays, a little staycation, in-state staycation. And we're driving to the mountains where there has been snow in previous winters. And so we had to do a quick inventory and see who still owned winter snow gear, because most of us wear shorts year-round here because it's just that warm. And so we did a quick inventory, and we had to in addition to all the gifts that we tried to buy, we had to buy just a couple things, some gloves and hats, and a couple pair of boots were missing. So let's see. Nurse Forgot sent you a text on the burner phone. Let me check here on the burner phone. There, I see you. Oh no, Brandy's not feeling good. Oh man, I'm sorry to hear that. And Nurglerot, I think I'm going to send you my information. Okay, here's my issue. Ready? This is my problem. There we go. Let me turn off that buzz, that sound. I'm using the Aero Pro 6 Plus, I think, mesh routers. It's a little white mesh router. If I hardwire directly through it, I can access the internet using my Mac on Safari, Firefox, and Chrome. If I use Wi-Fi, either of the two, the guest network or my main network, from those same devices, I can only use Safari. Everything else gets an error socket, some socket error. Or like the connection, like it doesn't exist, and it's instantaneous. Like it doesn't even hit the DNS. It just immediately kicks it right back. Safari works, but Firefox and Chrome, some of which when I run applications on those, I run Chrome plugins and things that I need for my channel. So I have to actually use something other than Safari. I cannot even get Opera. I forget what the browser is, which they recommended. I can't even get that to install because it needs to access the internet. So if I'm wirelessly connected, I can't even install that. So, Lynn in South Carolina. Time flies when you're having fun. Thank you very much, Lynn. Welcome to continue your 4th month, or I guess this is now your 5th month. Fun and funky. I was snowed in Raleigh, North Carolina, one February when I visited from the UK. That's the only time. I think they're still talking about that in Raleigh, the one time it snowed in. Diana Beatson said, my 1 month anniversary and birthday. Diana, happy birthday and 1 month anniversary. That is awesome. Congratulations and thank you at the same time. Love the picture of the pooch as well. Speaking of pets, before we kick off our marathon readathon, speaking of pets, some of you have made my cat's day. I will tell you that we have my cat now has all the toys. My cat has multiple scratching posts, a scratching lounge, little feathered toys, little rolly balls, little bells, several brands of catnip or several different variants of catnip. I told my kids it was cat marijuana. That my wife wasn't a big fan of me calling it that. But a cat house is heated. Let's see, the gifts to my cat go on and on. It is the most spoiled cat in the entire neighborhood. I know it's spoiled because all the other cats come over to our house at night and try to play with the toys and climb the posts and everything else. Thank you. I don't know who sent what because it came straight without any messages, but thank you very much. And not only that, I got one other little gift. I got a screaming goat. I got a screaming goat, just like Mike on Law Talk with Mike. It yells, and it's perfect. It is absolutely perfect. And then on top of that, Weather Watch sent me, you guessed it, Christmas decorations for my car because I won't decorate my house. So we're gonna put that. A camel. We're gonna put that on Mrs. RA's car. It's little antlers that stick up on the windows, and then you put the little nose, the Rudolph nose, on the front of the hood, and it's gonna be funny. Let's see. I skipped over your 5-month anniversary. Where did I skip over your 5-month anniversary? I just got ignored, says Lily's mom. Just had a 5-month anniversary, and he skipped right over. Oh no, Lily's mom. I am sorry. Where was it? I'm looking. Let's see. I see this one. Andrea Toma says, "Why aren't you doing the YSL gang trail?" Probably because it's going to take like 6 years to finish. It's crazy. Let's see. Diana, on my 1th anniversary, we got that one. Where's the 5-month? Snowden, Raleigh. Did I miss the 5-month? Time flies when you're having fun. Evie, welcome to the gallery. I'm missing some. I just didn't know I was missing some. Hang on one second. Can Mrs. RA do a recipe segment? I like that idea. I did not see the 5-month message. I apologize. I am so sorry. I don't know where the message went. It did not pop up on my screen. I don't know how to get it to pop up again. Let's see. Unless it's down further. Have I not got to it yet? No one can stream that trial. 6 months is ridiculous. Well, there will be a mistrial with only 6 alternate jurors. It's going to be so bad. It's going to be so bad. All right. Yes, the Young Thug trial. When we first, day one, when we tried to cover that trial, we were live streaming the courtroom. And in the courtroom, there was a monitor that was displaying all the people who were on Zoom. And somebody accessed Zoom who shouldn't have accessed Zoom. And instead of showing their face, they played a video. And the video should not be played ever. It was a highly inappropriate video. And that was our first day on that one. And we had, it was what we called a bad pickle moment. It was quite bad. And it was like live, and I didn't notice it for a little while. Okay, are we going to be covering Mr. Farag in Washington court today? If he shows up, here's what I did. I checked right before this live stream, Kathy. He has not been arrested yet. There is still a bench warrant out for his arrest. I did go back and look at some of his previous videos. There was a time he did show up in court with his dogs against the judge's order. There was a time he was arrested and dragged to court. He's had all the different ways of showing up in court, but I'm not sure if he's going to show up. I've looked. I have not seen anything today. If you see something out of Thurston County, I'm on it right now. I'm not seeing a live stream from courtroom 4. Let's see. 1 doesn't have it. 2, nothing on 2. Nothing on 3. I'm just not seeing it. Anyway, he's our pro se defendant that we covered just last week. Let's see, K-Rab says, moved from North Carolina from Massachusetts, MA, in February 96. We already had 108 inches of snow. Life went on. In January 08, Cary, North Carolina got 18 inches. Everything shut down for a week. Last real snow we've had. Yeah, that's 18 inches is a ton of snow for North Carolina, especially in the Raleigh area, which Cary's not far from. Let's see, the Chad Dorman trial in June. What else do we have going on in June? I need to look. We need to look at that. I think there's another trial happening about that same time. So we had a not suitable for court. That was a rough day. I had to immediately not only stop the live stream but delete the live stream. It was bad. So Frog's on the lam. Mr. Frog is not where he should be. So I don't think he's going to be in court. Chad Daybell's in April. Okay, that's probably still going to be going on in May. That's probably a 2-month trial. Snow in Orlando. That's going to be a cold day when it snows in Orlando. Lots of people are getting snow today in the middle section of the country. Lots of snow. Okay, Adam, I'm not even going to click on that. Not even going to click on it. All right, let me tell you, Corey Richens, possibly Corey Richens. I don't know. I don't think they've set the date for Corey, and when that happens, we want to be there for that. Sandra's birthday, is that today? Happy birthday, Sandra. Or is that in June? Sarah Boone. Sarah Boone, I checked on that before we went live today. We have a trial date scheduled for the end of January right now. I think it's January 29th is the start for trial. But there's also a hearing scheduled for January 16th or so, just to make sure we're on schedule. So, well, that hearing, when that happens, then we'll know if Sarah Boone's going to go ahead. But yes, early next year, Sarah Boone's probably one of the first big trials we're going to have, if that moves forward. Thanks for that, Crazy Cat Queen, as well. Please cover Chad Daybell. Oh, man, that's going to be a tough one. I want to cover Lori in Arizona. That's what I'd really like. Father took the lives of 3 boys. Man. You guys ask for some tough cases. I mean, the Lori and Chad one is tough as well. But at least we've been exposed to it for a while, and the shock value is starting to wear off a little. Brenda, welcome to the gallery. Thank you very much. Are you guys ready for me to start reading? We're going to focus on some documents. What state is Mr. Frog from? He's from Washington in Thurston County, and he has a long rap sheet, mostly involving traffic offenses, honestly, and a few related things ancillary to them. Lots of crazy cases coming up. The world of crime never gets uncrazy. Let's see. Mr. Frog speeding down I-5, passing truck on right now, probably. Yes, please start reading. Okay, we're going to do that. Let me tell you what's happening. I do need a couple people to keep an eye out for on the Sarasota clerk.com page. For the Maya Kowalski trial, we want to keep an eye out for the plaintiff's response to the filing.
When are we going to break for lunch, Judge?
Any minute now, I'm sure. Any minute now. So we've got a couple things that were filed on the 24th, or at least timestamped on the 24th. That just appeared on the docket today. We're waiting for the stuff that's being filed today from, I believe Nick said he was going to file it. So we want to watch for that. So keep an eye out. If you see that, let me know. What we're going to look at here, let's see. Let me pull up. Is it on 7? It is on 7.
Have them send someone with more experience.
Yes. Okay. Somebody told me this already. Let me pull this up. This is the latest defense document. Not the latest, because they did also file like a notice of filing trial testimony of Eli Neuberger. But the defense filed into the record the slideshow that the plaintiff used to show all the monetary damages during their closing statements. So I think they want to use that as an argument back and forth. I think there was an issue of $100 versus $300 an hour. Anyway, that's in there, and it's stamped across it, confidential work product and everything else. But it's in now. So, and it's all public. You can see it. It's just it's a PowerPoint is all it is. They filed that. They filed a couple other things there. But those appendixes, they weren't much. The big thing that they filed was the motion for directed verdict and a new trial. Remittitur.
Squirrel.
Remittitur. I don't even know what that word means, but this is what we're going to read right now. So, and I don't have any water, so we'll see what happens. I'll page my kids. So the defendant, and this is going on. This is going on. This shows just a little bit. It shows just a tiny bit what the defense thinks about the current position they're in. Because if you look in the
have them send someone with more experience.
Yes, always a good idea. If you look in the description of the video today, I included a quote from Carl Sandburg, and the quote says, "If the facts are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and yell like hell." And I think that is what is happening out of JHACH lawyers. They are pounding the table and making as much noise as they possibly can. And you're going to see throughout this motion that is filed, just that they are using the most flamboyant language, that they are talking to the extreme in almost every setting. And
what more do you need to see?
And pretty much they're saying, look how bad it is. It's obvious. There's no other solution than granting what we want, which is a new trial or the judge to strike this down. As a matter of fact, they say we're going to get to this, but I'm going to cheat ahead a little bit.
Is that correct?
That's correct. They say the numbers that were used by the jury to calculate the damages were so high, the judge can't even use them to get to a lower number. I'm not sure about math, but basically they're saying that the numbers are so big, you can't subtract enough away from them to return back to where we should be. All right, so here we go. Let's go ahead and give it a little bit of a read here. Do we need me to be a little smaller so you can see what's happening? If I shrink down over here, is that all right? Where's my? Hang on. Upstream key here. Let's drag me just a tiny bit further over there. How about that? There we go. All right, here we go. So this is the renewed motion for a directed verdict. A directed verdict, once again, is, yes, they mentioned Frag live now. Whoa. You can't say they just went live now. Is it on Court 4? It is. Wait, hold everything. Let me see if this is actually going to happen. Okay, go here. Where'd it go? Okay, hang on.
Have them send someone with more experience.
Send somebody with more experience. If he actually showed up, this is going to be incredible. Let's see, don't need that one. These are all the websites that wouldn't work before. Let me shrink that down.
When are we going to break for lunch, Judge?
Hang on, I'm trying to find him. Just one second. Let's shrink this down. That one. Hide that one. Where's my... Come on. Thurston County. Where's it? Okay, it's right here. All right.
Because he's the guy.
Let me see what's happening here in Thurston really
State's
quickly.
Position is that the last date that the trial was scheduled on, it was continued because another trial went, specifically one that contained the two attorneys involved in the Mr. Paul case. So it would have entered an excluded period due to counsel unavailability and would expire 30 days upon completion of that trial.
This is the same courtroom that Mr. Frog's supposed to be in, but he's not there.
I agree that it does expire today. I apologize. The 90 days was up yesterday, so today would be the expiration date.
Ms. Okay, so I'll come back to that in a second. Ms. Rowe, what's your position on where Mr. Farley is on speedy trial?
Mr. Farley?
I
think we've got a different guy
more
here.
Time than that. I don't know if I have done the calculation, however.
Okay, we're gonna bail on that cord a little bit. It can be rewound if you want. I mean, I can take a peek, but there's no. It's only been going for 2 minutes, so there's not. Let's see. I'm not seeing where. I definitely don't see Mr. Frog anywhere.
Break for lunch, Judge.
Yeah, we're gonna break for lunch. I'm gonna show you break for lunch. All right, here we go. All right, so let's start reading. If you guys hear Mr. Frog pop in, let me know. Let's see. Legal Vices and Megan Fox are going over this too. JHACH isn't even hiding their insults anymore. It's disgusting. They did a great job. Megan Fox and Legal Vices did a joint stream over the weekend talking about this. And big props out to Megan. She got a copy of this before it was posted. That's awesome. That was a huge scoop. That is amazing. And she did a great job with it. Great. It was wonderful to go over that. We're going to cover some of this as well. Maybe a little bit different vantage point or a different opinion on some things, but that's all right. It's all cool. Is this courtroom or junior high classroom? We'll find out shortly. All right. Let's read here. All right. So defendant Johns Hopkins Children's Hospital, pursuant to Florida rule, timely moves this court to grant 1, renewed motions for the directed verdict, and if those motions are denied, 2 motions for a new trial, or 2 motions for a new trial. If these motions are denied, motions for a remititure as to each of the 3 plaintiffs and to each of the claims submitted to the jury on the verdict returned on Wednesday, November 9th. So there are 3 things. Somebody has to define remititure for me. I could Google it, but that seems like too much work at this very moment. Let's see if my computer will work right. Define remititure. To send back, to remit. The purpose of remititure is to give a trial court the ability, with the plaintiff's consent, to correct an inequitable. It says it can donate. That's nice. An inequitable damage award or verdict without having to order a new trial. So fixing the verdict without actually having a new trial. So they don't care which one it is, as long as it's one of them. Reduction in money when the judge lowers the award. Reduce the verdict. Thank you very much. Decrease the verdict amount. All right, so this is what they want. New motions for directed verdict, meaning the judge sort of, in spite of what this would be a judgment notwithstanding verdict, I think. In spite of what the jury's done to find differently, to reverse everything, with a jury of 1 just being the judge, they want a new trial, and if that doesn't work, then lower the amounts. The defendant also moves this court to grant the same motions concerning each of the claims for punitive damages for the 3 subclaims for false imprisonment and the 1 subclaim of battery, for which the jury returned the bifurcated verdict later in the day on November 9th, awarding a total of $50 million to Maya Kowalski as punitive damages. This motion is unavoidably lengthy. Here it is. They start in unavoidably. They use very big words. And they will say that there's nothing we can do about it. There's nothing the judge can do. There's no options. They say there's no way anyone proofread this motion. Watch for all the admissions of their guilt. Hey, it's in the record now. It's too late. Oh, they're calling up the Frog case. How is this possible? Hold on. We want so much to see this. Play.
And so,
Have them send someone with more experience.
Let's update
the clerk's office. He has a number of failed to appear today, Your Honor. He also
back up
on 2A0074.
Here we go.
974. What's the state's position on that?
He's failed to appear today, Your Honor. He also, again, the court did properly note that he left during the middle of trial. I will note that he did call to court to find out a verdict. I think he also called to verify other dates of particularly this case, which was noted, I think, by the clerk's office. he has a number of cases, so I don't know if it was specifically this one, but he did call about another case to the court. With that all in mind, he's not appeared today. I don't expect him to appear today. He's been to this building for trial. He knows that trials are in this building. We'd asked for a bench warrant in the amount of $10,000. He has a pretty bad failure to appear history, and the fact that he absconded in the middle of trial is pretty concerning. And we would ask for a $10,000 bench warrant. Recognizing the nature of the charges.
Go ahead. I'm sorry. I thought you were done.
Sorry. And that is with the state acknowledging that the nature of the charges are, I think, what most people generally consider relatively minor. The fact is we need to get these cases resolved. He drags them on and then fails to appear. The state has significant concern about getting these cases resolved.
It's somewhat of a moot point in that a no bail warrant issued in the case that he was on trial on warrants listed in the amount of $5,000 cash or bond on this case. The other dates in the other cases, they'll remain. They'll probably get warrants on all of those too if he doesn't appear there. So, Mr. Pazderka, you want to find out? Can you make an effort to find out if you can get an ETA for Mr. Paul? And then with regard to Mr. Farley.
Okay, so that's all they're doing.
I know I asked, remember this was on for confirmation last week.
Okay, so we're going to turn that off. So, yeah, another warrant. Warrants upon warrants is what Mr. Farag has. Yet he absconded during trial last week. Didn't come back when it was his turn to present evidence, which he was going to be his own witness. Didn't come back. They issued a bench warrant, no bail bench warrant. Proceeded with the trial. Found him guilty. He called into the court. He's like, "Hey, I know I skipped out on the last part. Can you just tell me how it ended?" and then he said, "When's my next court date?" And then he didn't show up for that anyway. Okay, so that's where it's at. We're gonna have to wait till the sheriff finds him before court can proceed, I think. Okay. Let's see. Ivan, yeah, his excuses for not showing up are hilarious. If you go back and watch his videos where he brings his dogs to court, that is an incredible day. Anyway, the judge was not happy at all. The dogs were in the courtroom. All right, so this motion is unavoidably lengthy. Going back to where we're supposed to be reading today. But in the end, the court has little choice but to direct a verdict on all claims for which this defendant should have received that relief earlier, and to grant a new trial on both liability and damages for any remaining claims. You have no choice, court. It's all you can do. The jury voted yes on every possible method to award compensatory or punitive damages against Johns Hopkins Children's Hospital. Under the leadership of juror number 1, who they've already taken aim at, the jury voted yes, despite the fact that under the law instructed by the court and the evidence presented during the trial, many of the claims were not proven, or, at minimum, the manifest weight of the evidence was contrary to a yes vote on those claims. So he's saying the juror number 1 was the ringleader and led them down this path, even though they shouldn't have reached it. This court allowed plaintiff's counsel to use an improper method of closing argument that was intentionally designed to mislead the jury about both the method to decide damages and the reasonable range in which the jury was free to operate. In the improper closing argument, plaintiff's counsel requested aggregate damages of $201 million, $201.5 million. The jury awarded $211.5, approximately 105% of that request. Both the awards for the personal injury claims of Maya Kowalski and for the wrongful death of Beata Kowalski are many times higher than the range currently awarded by other juries and recognized in case law for such awards. Under the leadership of juror number 1, the jury's verdict was obviously tainted by the improper closing argument of plaintiff's counsel, but it sometimes awarded amounts even higher than plaintiff's counsel requested. If it is patent that the jury did not award non-economic damages as if these claims had been tried separately. And the same is true for economic damages, for which the duplication of award is rampant in the verdict. They're saying they've complained that the jury, in meeting all these things, overlapped. And now this isn't actually a legal issue. This is a problem if they have. The jury is not allowed to compensate you for one issue, and then if that issue sort of overlaps the other, they can't compensate you separately for the other. Where they overlapped, you can't duplicate. You can't double dip. It's just like when you go to the grocery store and you bring your coupons and it's like buy one, get one free. And you're like, well, I have 2 coupons, so I should get 2 free. No, you can only do one, right? You can't double up on that. So they're saying the jury doubled up where they shouldn't have. And let's see. Megan Fox or something just filed a supplemental motion. Let me look and see if it's showing yet. Hold on one second. Not yet. It's not showing. I mean, there's a couple appendixes showing, but and they're short. They're 3 pages, 24 pages, 6 pages, and 3 pages. A couple appendixes. They're medical billing records. They are. It's just like documents. Okay. So where we are. This court, before that closing argument, committed to following the law after the return of the verdict if plaintiff's argument resulted in such a massively tainted verdict. Massively tainted. The awards are so arbitrary that they cannot even be used as a reliable measure for a mitigator. They are so big that you can't even reduce them based off the original number. That's how big the number is. The only number that works for in this argument is infinity. Seriously, they're literally saying you can't get there from here. It's like on Google Maps. If you're like, hey, how do I get to the courthouse? And it's like, I'm sorry, you can't get there from here. Of course you can get there. There is a way to get there. There's math the judge can do if he felt that the award was too high to reduce it. He can reduce it. But they're saying the award is so high, you can't even reduce it. It's too big. So a remitigator in this case would simply require the court to serve as a fact-finding jury of one. A jury of one. They want the simple judge. You just go in there and act on your own and decide what to do. This court must grant new trials to liability of the damages on any claim for which a directed verdict is not granted. So they would like a juror of one, just not juror one. They don't want juror one. They want a different juror one, namely the judge, as long as he rules in favor of them. Otherwise, we want a new trial. Seems simple. After the jury returns its verdict determining liability, compensatory damages, and making changes on the substantive issues, allowing for an award of punitive damages, this court proceeded immediately with an abbreviated trial on the amount of punitive damages, in part because this case needed to be completed on November 9th for the reasons asserted by the court. Oh wait, you rushed us, Judge. You rushed us on the damages. Took too. You made it too quick. We weren't ready. 5 years was not enough. The plaintiff proposed a verdict form for the first time that included a claim under Section 76.8.731C that the punitive damages should be unlimited because the defendant had a specific intent to harm Maya Kowalski. Not only is there no evidence that this would establish that claim, but that claim is very clearly a substantive. Sorry, I'm making up words. Claim involving the entitlement for damages in excess of those normally allowed under the section. As a matter of basic due process, this claim needed to be pleaded in the 8th amended complaint by something more than a conclusory claim that the defendant had acted willfully, wantonly, or maliciously. The defendant needed to have the opportunity to present evidence on that claim prior to the initial verdict of this bifurcated trial, to move for a directed verdict on the claim at the close of the plaintiff's case, and to argue this matter in its main closing. Okay, so this is confusing, but they're saying the fact that you have this little piece in here that had the unlimited damages. Okay, remember that little argument they had? There's this one little part they wanted to include where they said, we believe the hospital had specific intent. They meant to do this. This was their purpose. And if they meant to do this, then all those guidelines for how much, or limits for how much the jury can go to as far as damages, those limits are gone off the table. It's like, jury, you write however many zeros you feel is appropriate. And they say, because you included that, you screwed up because you couldn't have used that. You couldn't have got there from the filing you initially filed. You had to have something else in there that would have warned us that this was coming. And this might be legitimate. Okay, this might be legitimate. Remember, the judge said, I'm going to include it because that way we have it both ways. So they're not happy about that. Instead, this court placed this substantive issue. Substantive. Why do I add an extra T in there? Probably because of remitigator. Affecting the cap on punitive damage on the jury's verdict for the second phase of the bifurcated proceeding. Bifurcated just means separated two parts. Where only the damage amount should have been tried. Moreover, this court declined to decide the question of law concerning the burden of proof for the specific intent finding. It thereby further emphasized this issue by presenting it twice to the jury under optional burdens of proof. The jury then returned a verdict, again voting yes on everything under the leadership of, guess who? Juror number 1. The jury awarded $50 million in punitive damages. Why, yes, they did. It awarded $25 million for 2 false imprisonment claims for periods where, 1, Maya Kowalski was treated in an intensive care unit, and 2, she was observed for 2 days in a rather ordinary hospital room, and the video recording evidence shows no mistreatment warranting any punitive damages. One of the appendixes they entered was a breakdown of the 978 2-minute segments from that video. They basically described what happened in a bunch of the sections, with her getting chocolate cake and asking for Gatorade and everything else. It's all in there. I don't want to show that because I believe it has unredacted Social Security numbers on it, and so I'm not going to put that up. The jury awarded another $25 million for a combined false imprisonment and battery, where she was placed on a bed either in her own hospital room or some other hospital room for a matter of minutes, on January 6th, which is the day she went to the courthouse. This is the day her mother wrote her suicide note, unaware of this incident. So $25 million, it only lasted a couple minutes, is what they're saying. It wasn't a big thing. They still don't get it. Maya Kowalski was held on a hospital bed to document. Maya Kowalski was held on a hospital bed to document the condition of her skin photographically prior to leaving the hospital. She has her shorts and bra on for these photographs, which are not shared or publicized at all by the defendant. We didn't let the pictures go anywhere outside of the hospital. It was just us that had them, so it shouldn't be a problem. It should be noted that the defendant maintained that she was actually photographed again on her return, but in light of the Maya Kowalski's insistence that it occurred once, this verdict is only for a single event. Maya Kowalski saw both her uncle and her psychologist, Dr. Duncan, on the same day. She seemed essentially normal to her uncle on that day, and she made no complaint to Dr. Duncan. The jury determines this conduct was more than an intentional tort. It decided that it was intentional misconduct. Let's see. M. Young says there are actually 8 hours unaccounted for in that 48-hour breakdown. Oops. Yes, she was held. She was held. They said they weren't holding her, but now they said she was held on that bed. Yep. That sounds like confessions to things they were defending, saying they didn't do before. All right. Let's see. Intentional misconduct on the definition of Florida statute, and awarded an amount of punitive damages that would be excessive, even in an Angle wrongful death case where the plaintiff suffers for years with breathing disorders allegedly brought on by an addiction to cigarettes caused by the fraudulent conduct of large for-profit international corporation. They're talking about like a tobacco suit, where they're like, hey, the tobacco companies knew that their product was causing cancer, and the years of pain and medical issues, there were huge amounts attached to verdicts in those cases. And they're saying, even in those situations, this is, way too much. This motion is filed with a mandatory 15-day window that is provided for all cases without regard to their complexity or length of trial. Right, we only have 15 days, no matter how long court was. If this was a traffic ticket, and the judgment had been found against us, we would also have 15 days. But no, this is a massive 9-week trial. You still have 15 days to file your motion for this new directed verdict and everything else. Although a full transcript was requested shortly after the return of the verdicts, and some transcripts of portions of the trial are available now, the motion for this exceedingly complex and lengthy trial is not as comprehensive as it would be with a full transcript with sufficient time to address the case, and that is easily 9 times more complex than the normal case in which such a motion is filed. I'm not sure where they're getting their math. Maybe a normal case lasts about a week. Maybe that's what they're hinting at, and this was 9 times that. This rule specifically provides for an amendment to the motion to state new grounds. The defendant has sought to identify each ground for this motion, but it will seek to amend its motion for any additional ground and to provide greater factual information and legal argument as soon as that is feasible. So this is the early copy. We're going to fix it. We're going to make it bigger, they say. We're going to add more stuff as soon as we get more of the transcript from court. And now we have a table of contents. This is very nice of them, so we can jump straight ahead to whatever crappy section, section we want to read to. So we've got renewed motions for verdict, motion for a new trial based on manifest weight of evidence, new trial based on errors occurring during the trial. Oh, that's basically saying the judge did it wrong. Motion for a new trial based on excessive awards or damages. Oh, the jury's fault on that one. Motion for remittiture of compensatory awards of damages. That's also the jury's fault. Renewed motion for directed verdict on claims for punitive damages. That's back on the judge again. Motion for new trial based on punitive damages contrary to the manifest weight of the evidence. So the jury calculated the weight evidence wrong. Yeah, we might have done something wrong, but it wasn't that wrong. So it shouldn't, there's too much weight on this evidence. New trial based on errors occurring during the trial relating to punitive damages. Motion for new trial based on excessive awards. This is all in Section 1. Applicable standards for these motions. Section 1. Then you go to Section 2, and it just continues. The court erred. The decision to grant the defense motion was an error. The grant of additional time severely prejudiced the defendant. Dr. Eli Neuberger's deposition testimony over objection, and they submitted his testimony into or at least the slideshow into the everything. Let's see, motions for intentional tort claims, false imprisonment. This we're still in the table of contents, and it just goes and goes and goes and goes. And this is the short version. Okay, now we're done with the table of contents. This is key. The defendant seeks a directed verdict on most claims. This is the judge going back and saying, in spite of what the jury found, in spite of them saying that, yes, we found that you did something wrong and you were liable, we'd like you to go back and direct the verdict the other direction and pretend like the jury never did that and reverse that. Bug Dugger, thank you for gifting 5 memberships. Appreciate that. Your generosity is amazing. Thank you. Should the court deny a directed verdict as to any claim, the defendant alternatively seeks a new trial on those claims for which a verdict has been denied. So if you don't flip the verdict to the other way to make us the winner, then we want a new trial. And if we don't get a new trial, then we want you to lower the amount. This is throwing everything you possibly have at the wall. This is all the spaghetti at the wall, trying to hope a single noodle will stick. So renewed motion for a directed verdict. They should only be granted when no view of the evidence or inferences made therefrom could support a verdict for the non-moving party. They literally think that no normal person looking at the evidence that was presented to them in this 9 weeks of trial could come to the reasonable conclusion that Johns Hopkins had any fault here. Because they want this on all 44, right? All the 44 options where the jury said yes. They want for every single one of them. They say there is no way. There's not even an inference. You can't even infer that we did something wrong in any situation. No normal person. Only the 6 people from the bus stop that can do this. Betsy Jean, time sure does fly. Already been here 2 months. And most of those months have been the Maya trial. Betsy Jean, wonderful to have you here. Thank you. Love that picture, profile picture. Looks like a cool, is it a charcoal drawing or pencil drawing? Looks awesome. A lot of spaghetti throwing. This is all the spaghetti. And this puts into perspective what happened with the juror motion as well. Because it has the same elements in it and the same absurd fervor, I guess is what you could say. The frantic fervor that please begging, no, don't make us pay, whatever. There's got to be a problem somewhere, some way we can reverse this. Karen Reese, it's been a great month. Thank you very much. Starting month number 2 with that blue courthouse. Thank you very much. Let's see. So in considering motion for directed verdict, the court must elevate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. Guess who the non-moving party is? The plaintiff, because this is the motion from the defense. So they need to look at the testimony in the light most favorable to the plaintiff. And they say, if you do that, that no reasonable person could find in favor of the plaintiff, even in the light most favorable to them. I don't think I mentioned this one, Kayla, and I'm just fine with that. I'm happy to be on the sidelines and not included in the court things. but I haven't scanned this document to see if we were included at all. Renewed motion is subject to the same standard. However, it's more apparent at the end of a case that an essential element of a claim was not supported by any relevant evidence, or that any evidence on the issue was not in actual dispute. Okay, so these are all things that have been raised with the judge once already, and they already went to the judge and said, look, we don't think that there is support here for these issues. You know, these counts, we want them thrown out. And lots of counts were thrown out. From the beginning, we started with, 22 counts? We ended with a handful, plus a couple. So lots of counts were thrown out. And these remaining ones, the judge already looked at and said, look, we have evidence that a reasonable person could look at, in the light most favorable to the plaintiff, the non-moving party, you've got an issue here. The jury could look at that and say, yeah, we could find fault here. So they've already looked at this. This is going nowhere. They're just throwing everything at the wall again. Motion for a new trial based on the manifest weight of evidence. This is basically saying the evidence that was presented was given too heavy of a value by the jury. You know, with us, you know, the battery. You know, if battery actually did occur and they acknowledge that it did, if I'm saying that, then you can't hit us with a huge fine because you said, well, because that occurred, then we're really bad. And I was like, no, we don't think we're that bad. Gaylor Rue, happy to have my courthouse back. Thanks, Bug Dugger. Thank you very much, Bug Dugger. That was very generous. We're at a bus stop waiting for a bus going nowhere. The worst companies are the ones that have decided to pillage the reputation their predecessors built. JHACH is a prime example, says Sheraz. Let's see. So remediatur would be that this case be retired or the damages awarded by the jury reduced. Damages reduced, Karina. That's what they want. Well, they want to start over. They would like either the easiest thing for them would be for the judge to say, you're right, I'm going to direct the verdict, and I'm going to just cross out where the jury said yes, and I'm going to write Judge Carroll, no. That's what they want. And so they're saying on every single count, Judge, just cross out what the jury said and mark the other box for us. And if you won't do that, then for each one you won't do it on, we want a brand new trial. And if you won't do that, then for each one that has money damages associated with it, we want you to reduce the money by crossing off several of the zeros. That's all. All right, so to get into a little case law, the trial judge should always grant a motion for a new trial when the jury has been deceived as to the force of the credibility of the evidence or has been influenced by considerations outside the record. Let's see, they found a case law that says this. They think clearly that's the case. Okay, let's see. There are aspects of this case that made it difficult for the jury to weigh the evidence or follow the law. The medical and scientific evidence was complex and overshadowed by the emotional impact of a good family devastated by a dependency proceeding that was beyond defendant's control. Apparently, the fact that we have legal experts or legal professionals, people who've served, and retired from law enforcement, people that work in the hospital or the medical field and understand in detail the law and the medical billing and the complex issues associated with that. They can't understand that, apparently, according to the defense. These were too complex. And the jury just didn't get it. It was all the problem the jury should have seen was everything was caused by this dependency hearing, which JHACH says, not our fault. We just called them over and over until they took over. We just called them. And then once they took over, you can't blame us for that. And you can't under the law. They are protected for what happened during the dependency proceeding because of Florida law. Now, does that need to change? Possibly. But they're saying that was the whole issue. Moreover, the infliction of intentional infliction of emotional distress without the additional unique factor of a suicide in this case. This case was groundbreaking in that it's the first case where you've ever had that intentional infliction of emotional distress linked to causing the suicide in a case like that where they're found guilty. Those have not been connected before. This is a ground-breaking case. And honestly, anywhere you break ground, that's something that an appellate court is going to look at very closely. Let's see. The jury needed to sort out the actions of the defendant's employees that were more than negligence and more than a mere traditional intentional tort. They needed to identify conduct that actually rose to the level of extreme and outrageous conduct committed with the intent or with the reckless disregard of the high probability of causing severe emotional distress to Ketamine Girl. Yeah. Kayla says, so they want to re-traumatize the family, subpoena all these witnesses and everyone again. That's the definition of insanity. They think that this jury was a one-off. That with a one ringleader, clearly they think juror number one made all this happen, which I think they are a little bit wrong there. I think just in the way little we've heard from juror number one is that basically everyone came in with their opinion and everyone was listened to and everyone was valued and they all agreed. That's I think what we've heard. Obviously, I'll leave that for them to tell when the time is right. Let's see. Finally, the standard on the job of the trial court is even more important in this case, which the theory is that the employees of the defendant committed conduct that was so extreme and outrageous that it was the legal cause of the person's suicide, a suicide that occurred not because those employees directly interfaced with Beata Kowalski after October 13th. Instead, a suicide that occurred because extreme and outrageous conduct of employees inside the hospital was either described to Beata by her husband or were experienced by her through some remote form of communication. So they're saying there's no way that you can connect the two, although the jury said yes, there is. Okay, because somehow the defendant's employees intended their actions to cause this extraordinary level of stress in a woman many miles away, a woman that some of the employees had never met, but some had. Let's see, the gatekeeping of the evaluating the manifest weight of the evidence for this claim is exceptionally important in this case of first impression. Motion for a new trial based on errors occurring to the trial. This is the judge. This is where they think the judge faulted. Let's see. During the trial, it is analyzed separately from the motion based on the manifest weight evidence. So this is you have to decide each of these separately. And they've used all these reasons for a new trial, and any one of them can get them to a new trial. But just because you ruled out option A, you still have to consider option B. This case, that case explains. Let's see, that's case login. Let's see. A new trial is required where the trial judge becomes aware of a specific prejudicial legal error or when he or she finds that the jury's verdict is contrary to the manifest weight of the evidence. They're still harping on that one. Case law, case law, case law. Let's see. I want to see what the exact complaint is on this one. The party moving for a new trial must show that there was an error, and if so, then the burden shifts to the non-moving party to show the error did not contribute to the verdict. This is a normal procedure. They're saying the party moving for a new trial, who is the defense, needs to show that there was a problem. They just have to show the problem. They say, here, an error occurred. This should not have happened, and it happened. Or this should have happened, and it didn't happen. Whatever it is. They have to show that there was an error in the proceedings. And then the other side, the plaintiff in this case, has to say, yeah, that happened, but it didn't impact the verdict. And that's that second part is very difficult to prove. A trial court may order a new trial on the ground that the verdict is excessive. This is a motion for a new trial based on awards and damages. This is the fourth reason for a new trial. Just there's too much money. The verdict was too high, so we need a new trial. Request for this new trial is properly made prior to a motion for a remitter. So they say the order is proper. We're asking for a new trial, and if you won't grant that, then we're going to ask you to reduce the amount. In that order, they have to be considered in that order. The legal question is whether the verdict is so inordinately large as to exceed the maximum limit of a reasonable range within which the jury may properly operate. That's a old law. I say old because that was the year I was born. So it's like 45 years ago that case law came down. Especially when the verdict is deciding economic damages that require proof of a clear factual basis for the damages need to be reasonably supported by the evidence. It is incumbent upon a plaintiff in a trial court to present evidence to justify an award of economic damages in a definite amount. Damages are recoverable only to the extent that the evidence affords a sufficient basis for estimating an amount of money with reasonable certainty. So they don't like the process they came to those numbers. While remittitur can be an appropriate remedy for excessive damages, that remedy does not replace the remedy of a new trial. There are times when it is impossible for a judge to perform the act of reducing a verdict. Let's see. If, in the opinion of the trial judge, it should be impossible for him to fix and determine a proper amount of remittitur, then he is directed to grant a new trial on the question of damages only. In this case, for many of the claims, the awards in the verdict are so excessive and so beyond the proper range due to the improper argument of the plaintiff's counsel that this court allowed him to make at his own risk, that they really provide no benchmark from which this court can perform a reduction as a question of law. Moreover, as a result of additional errors, sorry, I'm going to take this one down, Kayla, thank you very much. As a result of additional errors, a new trial is warranted on all issues for the claims in this case. All issues. And lastly, Part D, motion for remittitur of compensatory awards of damages. This is where they want them reduced to an appropriate amount. The defendant does not actually believe that any of the monetary awards in this verdict are sufficiently accurate and unaffected by passion and prejudice such that they could be used by this court to make a legal decision, as compared to a factual decision to reduce the amount in the verdict to an appropriate amount. If the motions that precede a motion for remittitur, that's parts A, B, C, and D, are denied in the order resolving those post-trial motions, the defendant will appeal those rulings from the final judgment that is entered either with or before any order of remittitur. That order gives the other party the option to accept the remittitur and reduce the amounts in the final judgment or to request a new trial. Seeking a remittitur is not a waiver of the right to appeal in the final judgment or in a conditional new trial order that is adverse to the defendant due to the rulings on the motions made prior to the motion for remittitur. Okay, so they're saying us asking for you to lower the amount does not get rid of the fact that that we still want a new trial. I'm saying it like a French word. I probably am saying it wrong. Don't quote me on this. Remittitur. I like the tour, Ken. I like to add the tour at the end. I know it's tur, which sounds very American, but tour has a superiority. A little. It's like drinking water out of wine glass type sound to it. Okay. Let's see. Can the judge say okay, then reduce by $1? If here's the problem. If the judge says okay, witchy mama, he's basically saying yes, there was a problem in how they did that. So if he does say yes, I believe there would be a sizable reduction, and they're going to then see probably one of the figures based on either the hourly rate they were calculating the damages. Say if it was $300 an hour or $100 an hour, that might be reduced by a significant number. It might be reduced in half. It's big. If he says yes. If he says no, there's obviously no reduction. Yes, je parle français, la langue de l'amour. I have to add a little French flourish there. That's all I know how to say in French. Like 3 years of French. I think I failed 2 of the 3 years. That's all I know how to say. Je m'appelle recovery addict. All right, okay. Unless I win the game, the rules are wrong or haven't been kept, and I'm taking my bet home. So there. Yes, J.H. Evans, you've clearly studied in the school of JHACH as well. This is how they seem to be filing this motion. Lori and TT, welcome to the gallery. Love that blue courthouse. Thank you very much for continued support. Okay, so let's see where we go here. Statutory grounds also serve as a guidance for when a new trial should be granted. They're pushing for the new trial. That would be their preference, is a new trial, because they think that lightning cannot strike twice on this. And clearly, any reasonable jury would see that there was no evidence in their minds, no evidence that the hospital did anything wrong. I don't think they're looking at the same evidence that we are. Let's see, since 1986, the legislature has required trial judges to engage in close scrutiny of jury awards to assure that they are neither excessive nor inadequate. This is true. And the judge actually warned them about that if they went too far, that he has no problem ruling against them. The statute lists the following factors to consider: whether the amount awarded is indicative of a prejudice, passion, or corruption on the part of the trier of fact, and whether it appears that the trier of fact ignored the evidence in reaching a verdict, misconceived the merits of the case relating to the amounts of damages recoverable, Whether the trier of fact took improper elements of damages into account or arrived at the amount of damages by speculation and conjecture. Whether the amount awarded bears a reasonable relation to the amount of damages proved and the injury suffered. And whether the amount awarded is supported by the evidence and such that it could be abduced in a logical manner by reasonable persons. JHACH is hemorrhaging money on attorney's fees and costs. Maybe they should remember their closing arguments. Think of all the children that attorney money could be helping instead of paying out more and more fees at $450 an hour. Let me say this. Thank you, Jennifer, by the way. I don't know when the damages start or when the interest starts accruing. I don't think it's right now. It might be in a couple days or a week or something. I don't know. If it's accruing right now, the interest that they're accruing is enormous. They need to basically write a check and put it in a trust, in this, and be held until this is all decided. And as soon as they do that, the interest stops accruing, at least on their bill, because then the interest accrues on the money that's sitting there, and yeah, it's like 12% interest. Yeah, it's a lot. I don't know the dates on that, but looking at that, as soon as they need to pay that, they need to pay that, or else they're literally burning money. Kathy D, welcome to the gallery. Great, love the Blue Courthouse. Thank you. It's like $250,000 per day, just a small amount of interest, $250,000, right? Interest per day. I'm guessing interest doesn't accrue until final judgment is entered. I think that's right, Courtney. It might be at an earlier point. There's some point where they have to have the money set aside in a trust, and I think it's before it's. I don't think they're billed that immediately when it's payable to the family. Okay, let's see. They're literally dragging this poor girl right through hell just to write the check and get on with her life. She's still young. She has a life to live. Yes, 50 Shades of Babe. Keep in mind that as soon as this verdict came through, the family took a step to proceed on additional issues against the hospital, specifically the SA issue that came up during trial as a huge surprise. Gray Anderson said $22,000 a day in interest. That's about right. Okay, that sounds more like it. $250,000. That's a ton. Either way, $22,000 a day is a lot of money. That's a lot. Okay. If they show they get it, they'd be agreeing to their misconduct. I just don't think it's going to happen. I will say this, Judy, you're right. Everything that we're seeing out of the defense attorney, the defense team, is what we would expect to see out of the defense team right now. This is what any good lawyer would do after you got beat soundly in court. See, renewed motion for directed verdict on claims of punitive damages. This is the $50 million. Same process as the other claims. Meaning they need to be able to reach their punitive damage. The jury need to be able to reach the amounts based on clear and convincing evidence. The evidence also needs to create a jury question on the high bars set by the Florida law. The employee's conduct must first meet these standards: intentional misconduct, gross negligence. In this case, the torts are not matters of negligence. They are intentional torts of false imprisonment and battery. Thus, although the plaintiffs actually pleaded none of these statutory elements, the awards in this case should not have been allowed to be based on gross negligence as compared to intentional misconduct, but this court ruled otherwise. Even under the gross negligence standard, the defendant submits that it was entitled to relief on its renewed motions for directed verdict. It's also entitled to directed verdict because there was no evidence that the director or officer of Johns Hopkins committed any of the acts specified. The purported manager involved in one of the claims was merely employed as a risk manager in the risk management department. The plaintiffs presented no evidence of that person's job description or authority within the corporation. They're basically saying the person who did those things wasn't even a manager. It was just somebody who worked for us. Weren't they faulted for poor oversight? Isn't that something that somebody alleged that they had problems with? Let's see. Sharaz just gifted 5 memberships. Thank you very much, Sharaz. Hope you had a fantastic Thanksgiving, by the way. Hunter shouldn't have buried the Dracula. The undead don't stay put. Okay. They didn't present the IJ, right? It's my understanding, Gerda, that the IJ has never shown up. That it's never, that the full IJ that we were looking for has never been delivered. There's lots of documents that reference it and paperwork around it, but it's my understanding that the full IJ has not been released or provided. Let's see. Motion for new trial based on errors occurring during the trial relating to punitive damages. This is where they say the judge did something wrong. Motion for new trial based on excessive awards of punitive damages. So the fact that it was $50 million is enough to get a new trial, apparently, for them. Motion for omittor of punitive damages. This is where we just want the $50 million reduced. This is a problem because, let's see, the court is complicated by the fact that this court allowed the unpleaded specific intent issue to be tried in the mini trial during the second phase of the bifurcated proceeding, which defense submits as a clear error of law and a violation of due process. Okay, they don't like how the judge handled this and allowed them to consider these punitive damages. Okay. Due process, 14th Amendment of the Constitution says that there has to be a reasonable relation requirement and limits the amount of punitive damages that constitutionally can be imposed on a defendant. That's and they cite the Philip Morris. This is the cigarette law, the cigarette case, the big one.
Have them send someone with more experience.
Next time. The U.S. Supreme Court requires courts to consider 3 guideposts in determining whether the award of punitive damages is unconstitutionally excessive. The degree of reprehensibility of the defense misconduct. How bad was it, what they did? The disparity between the actual potential harm suffered by the plaintiff and the punitive damages award. So are they equal? And the difference between the punitive damages awarded in by the jury and the civil penalties authorized or imposed in comparable cases. So you have to look at other case law as well. In this case, the $50 million bears no relationship to the injuries or the damages actually proved to be related to the false imprisonments and the battery and violates due process. They might have an argument to reduce this. I think that the hospital got what's coming to them in many ways because of how they've acted after this. Maybe the defense team should get fired. I don't know if anyone's getting fired yet. I did notice that Mr. Shapiro's name disappeared off a lot of the court documents, and maybe it just wasn't there before, but I just can't see it. But he's a member of he's still on the webpage for the law firm that Hunter works at. There's a Hall Ward or something. HWH Law is what they work at, and he's a shareholder there. Anyway, so I don't know if anyone's been fired, but let's see. In this case, what I'll say here is these punitive damages, as they relate, they were specifically for battery and false imprisonment. And we have to look at those and say, does $50 million match up with what the jury, with what the hospital did wrong? And does that match up with similar, and this is going to be the big one, with similar civil suits where those violations were found and awards were granted? And that, I think, is going to be the kicker, because they're going to say, where else has there been a battery or a 48-hour false imprisonment where you've had a $50 million punitive damage? That's going to be tough. So that might get reduced. Whoop whoop, 10 fabulous months with RA and our family of true crime. Thank you, Sharon. The months have been fabulous because of you. You are absolutely incredible mod and do so much to welcome people. It's wonderful. Let's see. Did I miss a comment here? Peggy says, I'm disappointed that you're not objective. I think you're siding with the irrational group for subscriptions. No, Peggy, I've just come to this conclusion. I started out being objective, and then I reached a determination. What I just said right there is I believe that this one's going to be reduced. I think the hospital has grounds for that. So I think I'm being objective a little bit. I think the vast majority of people who viewed this trial over on some of the other channels were in favor of the hospital. So you'd think if I was just going for subscriptions, I would try to target the people on that group instead of the minority. But Peggy, I would be happy to hear any comments or opinions you have. First of all, you shared your opinion very, very respectfully, which I am immensely grateful for. If you'd like to share more or have a discussion about that, I'd be happy to have that. It's I do welcome opposing opinions. I learn a lot from them, and oftentimes I'll even change my mind. Let's see. I would have awarded more money for some things and less for others, but my math is mathing sideways probably. I struggle with the math as well. And I think the jury did. We saw that one note that came from the jury during deliberations basically saying, hey, where are the notes on how much you're asking for? Because either I don't know how to find them or they're not there. And if you just depend on us, you're going to be lucky to have enough gas money to get home. I think that was humorous looking back on it now. It was an effort at humor, I should say. And they must have found somebody with notes. They must have found somebody with notes that had written down everything, because they almost nailed it. They got 105% of what the plaintiff had asked for, which is in the ballpark of what the plaintiff asked for. And the fact that the judge didn't say, no, you can't ask for that during the trial, that's outside the norm. That's too much. I think that means that there's very little chance it'll be overturned here. Possibly reduced. I appreciate everyone being respectful to those who have different opinions than myself in chat. So I appreciate that. Let's see. Sound and Fury from JHACH, not recovery addicts is what I mean. So few things are making sense. Thank you, Judy. Someone was a good scribe. Someone took it down word for word, I think, is what happened, and maybe made a slight error. Jen, thank you for the kind words. I personally, I've shared this before. I think the internet is big enough for everybody, and I think just like I realize we're a pickles, not politics, but let me talk about this briefly. I need to take this call because it's the inspector. 1 second. Okay, sorry about that. The inspector needed. They said, "Yeah, we're going to come and re-inspect your apartment, but you need to pay us more money." So hopefully you didn't read my lips and get my credit card number. All right, I was on the phone. I do apologize. Let's see. Is Discord better than YouTube for this channel? I don't have a Discord myself. There's a Discord that we're friends with, which is As the Gavel Drops. They do an amazing job tracking all sorts of true crime things, but I don't have my own Discord channel. Are you trying to get a hold of me, Karina? What let me know what you have. He's bribing the inspector. No, I'm just $75 for them to come back out and check something that they said was good before and now they say is bad. All right. Okay, Ivy Berlin says, I feel sorry for the family. The amount given to them is hard to believe. I think it's far too much, and I'd rather see this donated to prevent things like this in the future. I know that the family has said that they were going to start a foundation using a sizable chunk of this money. But we'll see. All right, let's go back. Let's read a little bit more and see where we're at on this. Let's see. Defendant intends to appeal the denial of those orders as adverse rulings. Issues affecting all claims. So everything, all the claims. This court erred in the application of Chapter 39 immunity, affecting nearly every claim in the case. Little problem there. Issues affecting all claims. And then they have this one word right here where it says nearly every claim. This means that this is all of them, and this means that this is most of them. And the two, ne'er the twain shall meet. They don't mean the same thing. It's interesting. Anyway, prior to trial, the court granted a summary judgment determining the defendant had statutory immunity under Section 39. We've heard that throughout the trial. For the investigation into that claim, DCF's decision to pursue a dependency proceeding against Beata and JHACH. In exchange for obeying the statute and for cooperating in good faith with both the DCF, Dependency Court, and DCF, the defendant was entitled to immunity for any act authorized or required by Chapter 39. They included keeping Maya in the defense hospital even after she was ready for discharge in October. Those acts included waiting for a transfer order to a facility that was better equipped and staffed to provide the therapies that Maya needed, and that order never arrived. The defendant could not transfer Maya to the hospital that provided ketamine infusions because none were known to exist, and the Dependency Court did not enter any order authorizing that treatment. The immunity should have extended to complying in good faith with the multiple orders entered by the Dependency Court regarding visitation and communications. But this court interpreted the protection given to the hospital very narrowly and allowed negligence claims as well as intentional torts to be litigated for actions which the defendant was entitled to immunity. Okay, now here's the problem. The way I remember these, and somebody correct me if I'm wrong, new motion today regarding a 20-year-old case regarding juror number 1. Where can I find that? Where can I find that? I'm very curious where that. Let me see if this is. Motion today regarding the 20-year-old case regarding juror number 1. What's the 20-year-old case? I don't know the details on that. Okay, the immunity should have extended to comply in good faith. This part, the problem I have with this good faith protection, is that if everything that the hospital had done, according to my recollection, and I don't believe it was, if everything the hospital had done was in response to a directive given by the DCF or the Dependency Court, then I believe that they would be 100% right in asking for this protection. If the court kept coming to them and saying, hey, this is what we want. But as I recall the evidence, the hospital would ask DCF to rubber stamp what they wanted, and then that would come back. And because they went that route, it was the tail wagging the dog instead of the dog wagging the tail. Let's see. Can we turn it down? I'll try to turn it down if the mods don't pounce on me. Let's try to keep the comments as relevant as possible. Let's see if I can. make it a little quicker. I realize it's hard for people to chat. Let's try to keep the comments as relative as possible to the topic at hand. That way it will be a little easier. Okay, Ashley, we're trying. I turned it down. Sorry, mods. Sorry. Okay. Yeah, no new docs on the clerk site. I just checked as well. I don't see anything yet. We are expecting a couple things. We are expecting, first of all, the plaintiff to file a response to the juror number 1 motions by... You lost the feed. What happened? I'm showing it's up. Showing everything's working. So we're expecting the plaintiff to file some motions that might hit the docket today, maybe later in the afternoon. Okay. To be clear, the defendant is not maintaining that statutory immunity would give it a free pass to torture a child or place a child in a dungeon, but acts like placing Maya in an ordinary hospital room to be video recorded to confirm whether her actions are consistent with CRPS or... Whoa. Why did they put her in there? Stop. But acts like placing Maya Kowalski in an ordinary hospital room to be video recorded to confirm whether her actions are consistent with CRPS or instead consistent with a psychological problem that may have been caused or enhanced by her mother's behavior should be the acts for which the dependent has immunity. The EEG room that they put her in because she was a fall risk, right? So too should the act of keeping the child in the hospital when the defendant expects the dependency proceeding based on the investigation commenced by its hotline report will be filed imminently. Oh, we expected to have approval, and so we kept her because we expected the hospital to be told to keep her. Photographs taken to document her skin condition before she left for court where her skin could be affected should be immune. Like the court would do something to her? Is that what they're saying? Defendant is not claiming that a typical malpractice claim for treatment in a hospital should be exempt, but after the entry of shelter order, the parent's right to make medical decisions did not extend to demanding ketamine infusions for their daughter at the hospital when prior infusions were a major component of the reason the DCF filed its proceeding. Bug Dugger, thank you. You're super generous today. Just gifting memberships all over the place. Ivy, you just got a membership thanks to Bug Dugger. Courtney Meek, Kate. Eggnog, Lily Wayne, you guys, thank you so much. Bug Dugger, appreciate that. The Kowalskis and their attorney could have filed an emergency petition to try to convince the dependency court that it should authorize such treatments, and then the child could have been transported to Dr. Hannah's office for that treatment, but they did not. And there is little reason to believe that a judge considering evidence that would have established that the standard treatment for CRPS in hospitals across America did not include high-dosage ketamine infusions would have granted that motion. A judge learning that this process was only being performed by a limited group of physicians, more as a matter of experimentation than as treatment modality, acceptable and appropriate by reasonable, prudent, similar healthcare providers, was very unlikely to resume high-dosage ketamine infusions. Thus, the medical negligence claim in this specific case is a claim for which the defendant should have the immunity because any ultimate decision to reintroduce that treatment following the shelter order was a matter for the dependency court. The claims for the intentional infliction of emotional distress could not be claims for which the defendant would be entitled to immunity if proven. The problem in this case is that conduct interrelated with or heavily affected by the rules and regulations imposed by the dependency court and DCR was often used to confuse the jury and to allow the admission of evidence that was not extreme and outrageous conduct intolerable in the civilized community. Kate says, so glad to have my courthouse back. Thank you, Bug Dugger. You are the best. All right, so they're saying that everything they did was right and should be covered by this immunity. Defendant recognizes and agrees that litigation immunity prevented use of testimony from that case as evidence against the party to prove liability, and likewise agrees that the court had discretion to limit extensive discussion of legal arguments and rulings in that case. But the fact that the proceeding existed and had a major impact upon the stress in the family, that the Kowalskis attended multiple hearings that upset them, and the full explanation of the hearing that triggered Beata Kowalski's suicide became off limits after the motion in limine was heard. This court, under the urging of the plaintiffs, transformed a statute giving the defendant a shield of immunity. Thank you, Eggnog. Appreciate that. Gifting it forward. A shield of immunity into a sword that was repeatedly used by plaintiff's counsel Objection, Chapter 39 was used to prevent the jury hearing relevant and necessary testimony and evidence, including, for example, the December report of Dr. Sally Smith. Okay, so the hospital wants it both ways here, right? They're saying that you kept stuff out because you said it was Chapter 39, but there were things we wanted to bring in. And if you remember the first half of the trial, one of the most common objections we heard from the defense team, to my recollection, is the objection because Chapter 39 prevented this from being presented. And while the plaintiff was presenting their portion of the trial, it was objection 39, objection 39, objection 39. And then we swapped the defense case. Defense gets up and starts talking, and Mr. Anderson's like, objection Chapter 39. And they're like, What? Why can't we say this? This is important to our case. They can't have it both ways. And I think they're trying to get it that way. Defendant believes the transcript will show instances where the court limited evidence based on Chapter 39 in its own motion. The court repeatedly told the jury the defendant was not responsible for Maya Kowalski's long stay in the hospital, but plaintiffs repeatedly presented witnesses or made statements in front of the jury about the child being trapped in the hospital. Maya Kowalski, both in court and on telephone recordings with her mother, was explaining how desperately she wanted to go home to her mother. Now, this is something they argue throughout the court. This is an issue that the defense team raised consistently through all the 9 weeks, periodically. More so during the plaintiff's case, especially as evidence was presented, and the witness would stray into that area about the time that she was held there. And that's why the judge kept giving those admonitions, saying, hey, just know the hospital is not liable for what happened during this dependency proceeding and for the actions related to that. Let's see, the limitations placed on this issue made it impossible for the defendant to keep the jury from being enraged about events and circumstances of which the defendant had no control and no legal responsibility, even though, in my opinion, they caused them. This is the most evident in the 3 claims for intentional infliction of emotional distress, but also impacted the claims for false imprisonment and battery. Given the size of the monetary awards, it appears to have affected all of the claims. The defendant submits this court erred in failing to grant broader immunity to this defendant and failing to permit a fuller explanation from the witnesses. So they want broader immunity and broader ability to share stuff for which they have immunity. And the judge, when the judge drew this line, and he said, this is my job is to find that line and draw it, and this is where I'm drawing the line. He was protecting, he drew the line and didn't let them cross for either reason. So they couldn't share information beyond it, and they also couldn't be liable for things that happened inside it. Judge is bad, jury is worse, we want to do over. Sarah, that's pretty much it. You could have saved them about 150 pages by writing for them. You might have a career in legal briefs. Ella Cole says, Scott, thank you for getting on this and not taking a wishy-washy stance on the BS defense is pulling now. Prouder than ever to be a member here. Thank you, Ella. I'm calling it like I see it. And I honestly, if I'm wrong, I want to be educated on that and point it out. I just don't see, first of all, the language we see throughout this letter, a new trial at minimum. They're talking with everything comes exaggerated. Everything comes across exaggerated. When you read this, you can see them flailing their hands and making exasperated faces. That's the tone I get as I read this letter, and it goes right back to that quote that I read at the beginning, where from Carl Sandburg, if the facts are against you, argue the law. If the law is against you, argue the facts. And if the law and the facts are against you, pound the table and yell like hell. They're making all that noise. They're pounding the table. They're yelling. They're waving their arms. They're making the faces. Which makes me feel that maybe their argument that the facts and the law are not really on their side as much as they'd like us to believe. Let's see. Especially in a case where a hospital has recognized, even before the entry of a shelter order, that a child needs special rehabilitation better available at other hospitals and the child is ready for transfer, its cooperation with the dependency court that never enters an order allowing it to transfer the child to a hospital with a specialized inpatient or outpatient program during the following 3 months should not subject it to the risk of a judgment. It certainly should not risk the possibility of the judge of the huge judgment in the jury's verdict would require in this case. If this judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody in its facility once the child is ready to be discharged to foster care. The hospitals will have little option but to seek an order from the dependency court transferring the child to a DCF medical foster care facility operated under the umbrella of the state's sovereign immunity. Why didn't they do that? I mean, I don't think that's what they should have done, but why didn't they do that? It's an honest question on my part. The court erred in allowing the plaintiff's attorney to make the massive request for damages generated by the per hour or per component closing argument, which affected every claim in this case. The court did allow that, and that's why we see in the appendixes that are attached all the mathematical per hour calculations, life expectancy, everything else. Defendant filed a motion to limit the use of an improper closing argument based on the method that deceptively allowed plaintiff's counsel to suggest awards as reasonable awards when they are many times higher than the maximum legal range in which the jury was actually free to operate. By dividing the damages into hourly amounts for components of the overall award, and this was Mr. Whitney, right? Mr. Whitney saying, you know, how much would you pay to get your parent back? Talking about the Onward Pixar movie, and how much would you pay per hour to get your mom back? It was brilliant. By dividing the damages into hourly components and employing a period of 8 hours or longer for each day and of a plaintiff's lifetime, this method can make an award exponentially higher than it is appropriate. And in this case, the plaintiff's counsel often used 12 to 14 hours per day at rates of $100 an hour to present with a straight face aggregate damages many times higher than the amount a reasonable jury would normally award. They used the hours per day based on the testimony from the Kowalskis, Kyle, Jack, and Maya, as to how much each day they spend thinking about this. That's where they got the numbers from. Gerda K gifted a membership. Thank you very much, Gerda. Appreciate that. Let's see. Hello again. Why do you think the hospital completely and utterly refuses to settle? It's quite strange. It can't be just ego. P. Will, for real, I am convinced that the hospital is convinced that they are right. And when you like, for every bone in your body believe that you are in the right, you'll stand and fight for that. I think that's what they're doing. I think they believe that they are in the right. So have they given up bullying YouTube creators, Jules, etc., or is this in addition to all the crap? This is in addition, Holly. This is in addition. We're going to see the response from the plaintiff regarding that motion that primarily targets juror number 1 and his wife, which is unbelievable. I personally think it's unbelievable. It's crazy. The amount of scrutiny that they are under when literally everything, even if you go through all the things that they've said, they're like, hey, finally the jury's made a decision, finally released from court. I'm just now hearing about all this stuff. I had no idea that I was they tried to kick me off the jury. The comments we got from juror number 1 in where he did post something online all show that he did everything right. And this is somebody who was in the legal, in the law enforcement world, who understood to some degree how courts operate and the importance of how these rules and following rules. Yeah, very, very interesting. But filing today, new motion regarding juror number 1. She has an inside scoop on that, which is awesome. I think she's made a connection with the plaintiff's team, and she's getting a little advanced access, which is cool. So we'll watch and see when it actually posts. It may be tomorrow or the next day before that actually goes in. Let's see. I have not heard I haven't talked to Rob since before the holidays, so I don't know. Don't know what his schedule is, if he's still celebrating or visiting or having guests over or something like that. So I don't know what his plans are. Possibly, if we have any of his mods in with us, they could give us an inside scoop. Will there be a hearing on this? Yes. If will he be live streaming it if they live stream the hearing? Jacqueline, I don't think that the hearing is going to be live streamed. The reason being is that the court, it might be on Zoom. And if it's on Zoom, I may be able to verbally recount what's happening in the court case. But it's pretty typical for this court not to allow the rebroadcast of their Zoom. And we have to abide by that. We have to follow the rules because that's what we do. But if it's on Zoom, I'd like to be able to watch and maybe give a recount of what's happening, even if it's just a play-by-play that way. I don't think that this will be something that the news cameras or any of the big corporations, whether it's Court TV or Law and Crime or something, send a crew down for, because it's hard. It's going to be a short turnaround time on the schedule. Okay, we don't know it's on the books. It might happen anytime between now and say the 15th of next month, and it might take an hour or two, and it's a really quick event to invest that much equipment and time into to get set up. So possibly on Zoom if the court decides to broadcast that. If they do, we most likely will not be allowed to live stream it. Let's see, how dare they be in the same house and be married? Yes, that was absurd. I know Reddit had a large group following. There were groups. I think Facebook was primarily where we saw groups that were in favor of the family, where Reddit was primarily where we saw people that were in favor of the hospital. But the different social media platforms obviously had people from every thought persuasion in there. Let's see. You've got the separate claims are given an hourly value of $100 per hour, which resulted in a daily total damage of $8,400 per day for a lifespan of 70 years. The aggregate amount requested by the plaintiff's counsel resulted in amounts spread among the various claims for her that totaled $64.5 million just for non-economic damages. Without considering income on that amount, that award would pay almost $1 million per year or more than the $2,500 per day for every day from the time this event until she dies. So they're really, really not liking the totals and how they came to these totals. Butch Jones gifted a membership. Thank you so much. Let's see. Ella says if hospitals settle, it'll be how many other similar cases against them come out? What is this saying? The lady doth protest too much or something. Ella, I see that. Yes. There will be lots of things coming. Butch Jones, thank you very much for the gifted membership. And Barbara Farthing, please cover the plaintiff's response to the thing about juror number 1. When should we expect that? Barbara, I was texting Dr. Joe when he was talking with Whitney this morning. Let's see. Give me a second here. Oh, here we go. FYI, the hearing on the motions has been scheduled for December 15th. Time to be decided. I'll keep you posted if you do the same. All right. Sounds good. Dr. Joe, just let me know. The hearing is scheduled for the 15th of December. And that might be for all these motions, not just the juror number 1 motion, but also this motion for directed verdict as well. So we've got just over 2 weeks for that to happen, and some documents will drop between now and then, for sure. All right. Let's see. Even more shocking, given Mr. Kowalski's life expectancy. Let's see. The jury. The math was $26 million. The jury gave him $50 million. That's more than $5,200 per day, and it too is awarded in a lump sum that will produce extensive income over his lifetime. Okay, here. Listen to this complaint. Within about an hour of the commencement of deliberations, despite the fact the jury needed to review an immense collection of exhibits and introduce into evidence, but not shown by either party during the trial, under the leadership of juror number 1, the jury was already asking the court to provide the documents and testimony that were used to support the huge aggregate award. Ultimately, the jury followed the argument of plaintiff's counsel instead of law and entered yes for every liability box and awarded damage amounts that were patently excessive and irrational when examined claim by claim. The award for Mr. Kowalski was for past medical bills totals 1.5 thousand, which clearly demonstrated. Okay, so there's a mistake right here. The award for Mr. Kowalski for past medical bills totals, it says 1,500, but then it has 3 decimal places and it ends with a comma. So I think this comma and this period needed to be switched around. So I'm not sure who typed this up. Was it Mr. Hunter, Mr. Shapiro? You made a little boo-boo here, and it's sort of significant. The decimal point usually is after the dollars and before the cents, just for your recollection, in case you forgot. So if it was 1.5 million, which clearly demonstrated that the jury duplicated damages, the award of $5 million for insurance fraud when plaintiff's counsel suggested $1 has even given this court a proposed judgment for only $1. Demonstrates that the jury was totally lost in passion and prejudice when considering the issues in this case. Simply put, the method was an artifice that misled the jury. A jury influenced by prejudice and passion has produced a verdict so unreliable that a new trial is need on all issues. Is need. New trial is need. I think needed. When you're typing this fast and you're spending this much money producing it, you don't have time for spell check. Who has time for proofreading? The decision to grant the defense motion for directed verdict on the negligent training claim only at the very end of the trial allowed the jury to be confused and misled by irrelevant evidence that impacted many of the claims in this case. At the beginning of the trial, Maya Kowalski also had a claim for negligent training. This claim, which was not eliminated until a directed verdict immediately before the closing arguments, allowed the jury to hear extensive, confusing, and ultimately irrelevant evidence that misled the jury and prejudiced the defendant. Okay, so this the negligent training claim was eliminated right before jury deliberation, basically, right at the very end of the case. This was where they, and honestly, it was eliminated because there was no law really that supported it. There wasn't a rule, a law that would support this charge. Hey, you failed to train your employees. And Mr. Altenbrand raised that issue many times during the trial. He's like, I don't know how to argue against this because there's no law about it. At the end of the plaintiff's case, the defendant was entitled to a directed verdict. The claim was presented as a common law claim of negligent training by a hospital as a statutory healthcare provider for training given to doctors and nurses who are statutory healthcare providers. It could never have been a common law simple negligence theory. This smorgasbord, look at that word, smorgasbord. I always thought there was a G on the end of that. Let's see if I can find out here. Hey Siri, how do you spell smorgasbord?
Smorgasburg. S-M-O-R-G-A-S-B-U-R-G.
Okay, yeah, so I was right. B-U-R-G, not B-O-R-D. Putting it in quotes does not make it spelled correctly. Smorgasbord. Hey Siri, define smorgasbord.
Smorgasbord means a buffet offering a variety of hot and cold meats, salads, hors d'oeuvres, etc.
Okay, so now it says smorgasbord is spelled correctly. Hey Siri, define smorgasbord.
Okay, I found this on the web for define smorgasbord. Check it out.
Okay, I think it's spelled correctly now. My phone corrected it to smorgasbord. Google has it spelled this way. It spelled it the wrong way first time, and now it's Siri caught her mistake. So I apologize, Mr. Defense. Apparently, smorgasbord was what you intended. I'm talking about a buffet. So this buffet approach to pleading produced a confusing and open-ended, unauthorized legal theory that allowed an extensive amount of irrelevant evidence about negligence on the part of the management and staff of the hospital to be presented to the jury. This evidence was then used by plaintiff's counsel as if it were evidence of intentional acts of extreme and outrageous conduct. and as if it were relevant to proving the distinctly different conduct by a managing agent necessary for corporate punitive damages. So they pled this charge, and it was in the case up until the very end. At the very end, the judge says, you're right, directed verdict, that's out. Okay, this intentional, the failure to train your employees, that's out. But all the argument and the testimony that led up to that was in. And they're saying because that argument and testimony was in, now we're at a huge disadvantage because there's no claim that went to. But it was there at the time. It was pled. Send someone with more experience next time. This court correctly, albeit belatedly, granted a directed verdict on the claim at the very end of the case. By then, the damage had been done, and that damage is reflected through the jury's verdict. The error was essentially harmful as it relates to Dr. Corcoran's testimony in the plaintiff's case and all that followed from that testimony in the defendant's case, and even more so in rebuttal. Dr. Corcoran could have never taken the stand on the liability theory unless count 14C was tried. A theory of management negligence was never part of the claim for medical negligence. This error requires a new trial for the entire case, or at least for major portions of the claims made by Maya Kowalski and the estate. They're saying that if they didn't have this claim for medical negligence or training negligence, right? What was it? Management negligence by failing to train their employees. They never would have had Dr. Corcoran on there. Wouldn't have allowed him in as a witness. The grant of additional time to plaintiffs in this case severely prejudiced the defendant. Hey, look, guys, we're already on page 38 of 155. Another week of this, and we'll get through it. After the defendant had carefully used limited time on cross-examination. So after we, the defense, had been so stingy with our time on cross, not asking all the questions we wanted to because we knew we had to save our time. In the plaintiff's case, in order to have sufficient time for its own case, this court granted the plaintiff additional time for its case on not one, but two occasions. Coupled with the inefficient manner in which the plaintiff's counsel introduced exhibits and the testimony of witnesses, these extensions placed the court behind on its timeline that required this case to end on November 9th. In the end, the defendant had many hours of time remaining, theoretically, when it rested. Okay, this is true. The defendant knew that it had time, but no remaining days to present more witnesses, or, for example, to present several hours from the video from the room on the 7th floor that contained the video and EEG equipment. In retrospect, given that it was clear that the jury did not review exhibits such as the EEG video clips, additional testimony would have been very important in preventing a runaway verdict on compensatory damages and punitive damages. They're complaining because of the time. They're mad that the judge gave extra time twice. The plaintiff used up time. Now, there were two clocks, right, for the trial. There were two clocks. One of them was that each side is given the same amount of time, and that number was raised during the trial. But the second clock was this case has to be done by November 9th, and that date was not moved. So in adding time to the plaintiff's side, it did disadvantage the defense side, because even though they had the same amount of time to present their case, they didn't have enough days left to get their time in. They might have an issue here because they did have to end because they were out of time. They had to rest their case. They made the decision to rest. The judge didn't force them to, and I think that might go against them. I don't believe that they said we rest, over objection. I don't think they filed an objection about that specifically. They made a choice to rest their case when they still had time left. Also would have forced a mistrial if it would have caused the jury to have no time to deliberate. By taking professional steps to fit this trial into the timeline required by the court, but skewed by the extra time given to the plaintiff, the defendant received an irrational verdict from the jury. It was then compelled to try both the substantive component and the usual damages component of the bifurcated punitive damages claim in an abbreviated mini-hearing that resulted in a $50 million award of punitive damages. And the findings on specific intent that were unsupportable under either of the two optional burdens of proof this court gave to the jury. Dr. Eli Neuberger's deposition testimony over objection. Multiple depositions were read and played to the jury during this trial. The parties submitted written objections a day or two prior to the use of deposition in open court. This court provided written rulings on the objections. In most cases, this process worked well. But on some occasions, and Dr. Eli Neuberger's depositions are the worst example, the worst, he's absolutely worst at this court allowed testimony to be presented to the jury that should have been excluded. This testimony included evidence, in air quotes, that was extremely prejudicial. His trial testimony has been transcribed and will be filed with this motion. It is cited in this motion as T. Dr. Neuberger is an elderly physician. He graduated from medical school in 1966, 11 years before I was born, and gained his first experience in the Vietnam War. He's a general pediatrician who is clearly qualified to testify about child abuse issues. When younger, he taught at Harvard Medical School and served on the staff of Boston Children's Hospital, but he retired at the end of 1999 and never had an actual pediatric practice. He no longer examines more than one child a month, and the last child he actually treated was his own grandchild. He is licensed in Florida only for the purposes of serving as a criminal prosecution expert. He is not board certified in the subspecialty of child abuse, but he was grandfathered into the society. Since 1999, his consultations in child abuse pediatrics have been his sustaining source of income. He does this for a living. Couldn't they have asked for an extension? Couldn't that be argued? I don't think they did, because he had his vacation. He wanted to end too. Yeah, this membership that he doesn't have, that he was grandfathered in, he didn't pay their fee. He just got grandfathered in. So yeah, old witness cannot be believed. Money 69, I believe they don't think this can happen again. They think that they had a perfect storm where lightning struck in the most unpredictable way. And they think that had the same effect, the same facts played out in a different setting, it would not have happened this way. Paid by the page. They're writing a ton. All right. Let's see. Let me go back to skip ahead to where we're going here. Let's see. All children's hospital are never have been. Let's see. The standard of care issues in this case concerning the healthcare providers at Johns Hopkins All Children's Hospital are not, and never have been, issues of child abuse. After the plaintiff withdrew any claim concerning Munchausen by proxy, the subject of child abuse had little or no relevance in this case. But Dr. Neuberger was allowed to become a jack-of-all-trades expert who opined on the unlawful acts and conspiracy of the doctors at Johns Hopkins All Children's Hospital, a conspiracy headed up by Dr. Sally Smith. He reached these professional opinions by reading depositions and records from the hospital. He was the equivalent of an expert juror in a criminal proceeding against the hospital staff. And this court let this testimony into evidence over objection. For example, this court admitted the following testimony to evidence at page 92 of the transcript. The portion of the first sentence in italics is the only portion of this testimony from the deposition that this court has decided to exclude. It is in the deposition, but not in the trial transcript. In addition to this opinion, I'm just reading this part here. In addition to this opinion, with regard to the team decisions, I intend to opine that this so-called team represented a group of individuals who together agreed to commit an unlawful act and to harm other individuals. Court ruled that out, and I don't believe the jury heard that. But then the witness's intention to opine was fulfilled when this court admitted this testimony. Maybe they did hear it. The court allowed Dr. Neuberger to describe the medical team, including Dr. Sally Smith, as conspirators acting on the basis of a flimsy notion, performing acts preposterously conceived and cruelly executed. Those are very flamboyant words, and they don't like them used against them.
When are we going to break for lunch?
When are we going to break for lunch, Judge? Here's the other one. Separation test, in my opinion, preposterously convinced and cruelly executed. So we've got more of the testimony here. He's not an expert on CRPS who was providing an opinion about Dr. Smith's opinions as a CPT leader that were in her report, which the court excluded from evidence. That's because, hey, Chapter 39, those opinions are matters for which she has immunity, and this court ruled, because of the immunity, it's not allowed in, and because the court ruled the defendant cannot be liable for her investigation, and most of all, he is giving an expert opinion on her credibility about whether she is faking behavior that he never witnessed himself. Although there are more examples, and his testimony is also discussed later in the section of medical negligence, and final example demonstrates the breadth of the prejudice resulting from the testimony this court allowed the jury to hear. Let's see, saying that with regard to the impact of the family, of Dr. Smith's and other Johns Hopkins All Children's Hospital workers. They have been more deeply informed with regard to the trauma suffered by the girl and her father with regard to their impact in propelling this mother. The mother has taken her own life with regard to the following impacts on the child with the trauma, which have produced an acute and concerning medical set of consequences that derive directly, in my opinion, from the malfeasance of the staff of the hospital. This elderly child abuse expert, so they're seriously saying the problem is he's too old, was allowed to testify that doctors far outside his specialty committed malfeasance, and their impact added to Beata taking her life. This was not expert testimony. The magnitude of this error is hard to measure, but the jury clearly measured it in dollars. I can tell you exactly how much they measured it. This error warrants a new trial on every claim. Motions for the intentional tort claims of Maya Kowalski. Intentional tort. This means they did on purpose, is what this means. They're talking about overlap here. Repeatedly concerning both evidence for liability and damages. The court twice told the jury that they should listen to the evidence and consider each claim separately, as if they'd been tried separately, but that it often did not explain that non-economic damages could not be duplicated. So they said, listen to each one separately, try each claim, but it didn't say that it can't be duplicated enough. They should have said, don't duplicate, as many times as they said, listen to each claim. You've got the settlement amounts here that they don't like there as well. The verdict, both as to liability and damages, is the product of plaintiff's strategy to create sympathy for Maya Kowalski that would overcome the law to place responsibility on this defendant for Dr. Sally Smith, Department of Children and Families, and the court system for taking her away from her mother. Cooper's mom, 7 months. That's awesome. Love that yellow courthouse. Thank you very much, Cooper's mom. See, I'm missing some updates. I'm not allowed lunch. I've waited all day for you to go live. It was the internet this morning. I had trouble with the internet. Jury's wrong. Experts are wrong. Judge is wrong. Everybody's wrong except the defendants. Yes, you're reading this correctly. Your notes are accurate. Lindsay, the 411 on the bus stop people, I believe that came from... It was, if I remember correctly, it's either Mr. Hughes or Mr. Shapiro. One of the two had written an email in response. I think it was to something from Reddit, or someone had communicated with them, and the comment was basically, "What do you expect? 6 random people from a bus stop to come up with?" It sort of basically just says these are, by saying they're people from a bus stop. It's sort of attacking them, sort of saying they're a lower class citizen because they ride the bus. That's like couched inside that whole saying. These are people that are too poor to afford a car. Of course, what do you expect they would come up with in a situation like this? That's how I read it. Go to page 49. Let's skip down a little bit. We've got false imprisonment. M. Young has hit the fast forward button. We're on page 47, 48, 49. Now let's see. The 2 calls. The defendant made 2 calls to report possible abuse to the hotline. The first one, they said, no, nothing's wrong. The second call was in Beata. Kowalski was apparently wanting to take her daughter home, and DCF acted on that call. Dr. Smith conducted the investigation. Why did they act on that call and not on the first one? Was there any information given to them by the hospital that was different on that second call than the first one? And was all that information accurate? Good question. Dr. Smith conducted the investigation for DCF during this period. Now, the hospital staff had a duty to cooperate with the investigation. The defendant is immune for these actions. Dr. Smith concluded there was a basis for DCF dependency proceeding, and the lawyers for DCF agreed. They filed the proceeding, obtained the shelter order, effective at 2 a.m. on October 13th. Maya Kowalski's testimony was that her memories of this period were limited. She did not like the clock in the room, and one nurse apparently did a transfer from one bed to another that was rough. She may have been dropped in this move, but there was no evidence of any injury or requiring treatment. Indeed, there is no evidence she sustained any physical injury from this imprisonment. There may be evidence of claimed medical negligence during this period due to unwillingness of the doctors to accept the diagnosis of CRPS as definitive and to begin treatment with ketamine infusion, a very high dosage that the doctors had no knowledge had ever been given to any patient. But that is not part of the intentional tort or false imprisonment and is a claim for which the defendant should have a Chapter 39 immunity, as explained earlier. We may have dropped her. But she wasn't bleeding, so there's no problems. It's this whole time the may have been dropped part. That's like, I think they were saying there was a fall. That's how we heard about it during the trial. There was a fall. She fell out of a nurse's arms. I don't know, but somehow she fell. But she's not bleeding, so it's not our fault. And it wasn't serious. It wasn't, I mean, there was no blood. So no harm, no foul, right? That is, say you dropped her without saying you dropped her. This is, oh my goodness. It was a rough transfer. That's what it was. It was a rough transfer. I'm imagining in my head when I think rough transfer, I'm thinking they take the one bed and they bring it up next to the other bed and they get over and they just give her a big shove and you expect her to just roll over and maybe the wheels weren't locked or something. I'm just trying to envision how this could have happened, right? You give her a shove to sort of get the momentum so their body would carry her over into the other bed and maybe they spread apart and she on the floor. Could have happened. Maybe it was a toss. You know, it was sort of like maybe there was like a chain, like, you know, when you're trying to put out a fire and everyone's passing the buckets from one person to the next. And it doesn't matter if there's a little spillage, as long as most of the water gets there, you just sort of heave the bucket, keep it moving. Maybe they did a chain of nurses to sort of one yanked her out of the bed, the other one tossed her to the next nurse, and tossed to the next. And somewhere along the line, maybe they weren't ready. Maybe it's like, oh, I didn't think you were going to throw right then. But there was a drop, a fall. She may have hit the floor briefly, but under the 5-second rule, we picked her back up again, put her in the next bed, and everything was good. Oh no, Mishmash! I'm sad because I missed my birthday on the stream. It was Saturday. Mishmash, you planned poorly. You should have had a birthday on a weekday. No, I'm sorry. Happy birthday, Mishmash. Happy birthday. I hope you had a wonderful birthday. Hey, how's it going? Let's see. Bravo Chick says, hey, RA and fellow addicts, 1 month already? Wow, time flies. Thank you very much, Bravo Chick. Great to have you here with a blue courthouse by your name as well. Brooks, mine was Sunday. So many birthdays. You know, we had a day without any birthdays. 0 birthdays. I think that was just like a week and a half ago. It was a minor. Don't sue us. Oopsie. Yeah. Well, the fact that this only comes out now, where before they say that she fell out of bed, right? She may have fallen out of bed. She may have fallen out of bed while we were trying to pull her out of bed and push her into another bed. That's when the fall may have occurred. Oh my goodness. IJ issues here with this drop. Should there be a record of this? Honestly, in the hospital record, should there be a little, maybe a couple notes like, hey, sorry, had a little boo-boo today. Picked up small child halfway through transferring to the bed, got a phone call, answered the call, didn't realize, dropped the child. Whatever the reason was, shouldn't there be some notes somewhere in the record? It's like, hey, I, nurse so-and-so, dropped the child on this time. Checked your eyes, not dilated, don't think it's a concussion, everything's good. There should be notes somewhere in the record that instead of just like, there may have been dropped. It was a rough transfer. Yes, everything is documented. The missus is teaching the kids right now, so she's not seen this yet. We gently dropped her. It was gentle. Because those floors are soft. On those kids' rooms, they use soft floors just for this very reason. You know, she laid there where we took pictures, so we forced her to lay down. They did say she was held down. Greener. So first they say that they may have dropped her, and then she said she was held down on the bed. That's the defense wording in here, if I'm understanding this correctly. Gail Pett, member for 9 months, says, hey, all, I've been here long enough to create a new human. Loved every minute of this channel. But instead, during that time, what have you done, Gail? You've made this a wonderful place for everybody else. Loved every minute of this channel. Chat, mods, and especially Recovery Addict. Thank you, Gail. Thank you so much. It would not be the same without you. Appreciate you being here. All right. Let's go back to reading. We're going to see what else they're confessing to in this motion. Okay. During the defendant's case, evidence including an email from Beata established that at the time of the email, she was not demanding that her daughter be returned to her to take her home. The child's condition, the medical history obtained by the hospital was established in the defense case, although these matters were not an affirmative defense. There's a renewed motion for a directed verdict and motion for a new trial based on the verdict against the manifest weight of the evidence. Wow. How many motions can you staple together in one motion? Okay, so the weight of the evidence, they don't like that. That's specifically related to that charge. That they're not talking about the drop anymore. They're on to other things. See, the sheer speculation by the plaintiff that the doctors hatched a plan to imprison Maya when the truth is that her treating physician sent her to the hospital for emergency treatment is not worthy of this court's acceptance, even though it appears to have misled the jury. Okay, so the treating physician, the hospital had wanted zero to do with the treating physician. And when they wanted to find out what was happening, they did not do the research to see what the treating physician authorized or prescribed. Instead, they immediately jumped to medical child abuse and then did not file a complaint against the treating physician.
Don't miss the forest for the trees.
Right. New motion for trial on excessive compensatory damages, also relating to this case. The false imprisonment and dropping. Can we combine those into one motion? False imprisonment and dropping in the hospital emergency room and intensive care unit where she stayed for about 6 days of medical care before being transferred to the 7th floor. Probably rough transfer. Is that where the rough transfer occurred? The jury awarded Maya $2.5 million for medical care and psychological expense in the future. Had this claim been tried separately, it is inconceivable that a jury would return this verdict. There is no evidence in the record that this event, a stay in the hospital room for 6 days before a legal stay for several months, required medical treatment or psychological treatment even in the past. Yet Mr. Kowalski was awarded $67,000 in past medical expenses for the care of injuries caused by this event. Neither Mr. Whitney nor Mr. Anderson suggested specific amounts for this event. Okay. Getting okay. But they ignored the law and presented a huge ball of damages. It was a ball of damages. Talking about play ball, they brought the ball, and it was a huge ball of damages. Okay. They ignored the law and presented their huge ball of damages to the jury. In addition to these awards, the jury awarded $3 million in non-economic damages for this event, for an event that did not involve any of the usual facts of false imprisonment. You know the usual stuff during a false imprisonment? We didn't do those ones. This was a unique false imprisonment. She was not locked. This is the usual stuff, right? She was not locked in a dark closet. She was cared for in an intensive unit. We didn't use the dark closet this time, Judge. So can you get a pass on this one? I guess that's the only way false imprisonment can occur, is if you use the dark closet and the lock. This is only the first of many awards of pain and suffering in this jury that exceeded the bounds of any reasonable range in which a jury could possibly operate. Even a verdict of 10% of this amount, $300,000, would be excessive. Here's where their first number. This is where they've actually volunteered a number. 10%, even 10% is too much. Under the law discussed earlier, if this is not a verdict that could be used as any gauge to award remittiture, it requires remittiture. Sorry, we're adding meatballs to the smorgasbord. I tell you, it's all you can eat here. Anything you want, we got it. It's like what's that? Golden Corral. That's what we have right here. Motion for requires a new trial, not merely on damages, but on the entire claim. Once again, new trial. That's the only option, Judge. It's the only thing you can do. Motion for remittiture on excess compensatory damages. The evidence is so limited as to damages. Let's break for lunch. On this claim, that it's actually hard to apply the factors in the statute. The award is indicative of prejudice and passion. The jury was misled by the closing argument and ignored the evidence. How do they know that the jury ignored the evidence? Is it not equally as likely that the jury heard all the evidence and made a decision based on it? The award was based on speculation and conjecture brought on by the huge lump sum recommended by plaintiff's counsel. The award bears no relationship to the amount of damages proved and the injury suffered, and the award could not be adduced in a logical manner by reasonable persons. Reasonable people could not come to this conclusion. So their six bus stop people are not reasonable, is what I'm hearing. Let's see. The plaintiff has the burden to prove reasonableness and necessity of past medical expenses. They usually do this by having the plaintiff testify about past medical bills, which is what happened at Albertsons, or through expert testimony regarding the reasonableness of the past expenses. The medical bills, the medical bills are not enough. We're not breaking for lunch. We're not going to break for lunch. Okay. For this claim, there was no such evidence presented to support an award of $2.5 million. This is true for claims throughout this post-trial motion. As explained earlier, defendant submits that this verdict is not even a reliable measure from which to conduct any legal analysis of remittiture. But if stripped of its statutory immunity and faced only with the option of a multi-million-dollar judgment, defendant submits that the maximum lawful range for future economic damages for these few days of hospitalization would be a few $1,000s, perhaps $6,000. Maybe $6,000. That's their counteroffer. All right, we're ready to settle. We are ready to settle. We're ready to settle. Hospital has brought a number to the table. Brought a number to the table. If everyone wants to come out and just, we're going to pass this note around and just think to yourself, is this appropriate? $6,000. They spent more than that writing this paper. The non-economic damages are for an event that was in a hospitalization sought by your own treating physician. It is an event that does not even remember. She does not even remember. She doesn't remember. Why did she get anything if she can't remember? Could be related to the fact that we dropped her on her head or something like that, possibly, allegedly, but maybe not. But if she can't remember it, may be worth a few $1,000s. So what? We'll go from 6 to 10, right? We'll be generous. Round up to an even 10,000. But there's really no evidence to support damages for Mr. Kowalski in this event. Let's see. Renewed motion for directed verdict on these punitive damages or in the alternative motion for a new trial on grounds of manifest weight of the evidence concerning punitive damages. This analysis starts with actions of the doctors in the emergency room and the intensive care unit. Ivan says, my dad turns 80 tomorrow. Can you sing in Russian for him? I can barely sing in English, Ivan. And my Russian accent is a crime. Literally, it's a crime. The only thing I can do with a Russian accent is say, "The Americans, they are here." That's it, and it sounds more German. So, sorry, Germany. That's bad your way as well. But happy birthday to Ivan's dad. Congratulations and our condolences on Ivan. I'm just kidding. Ivan, we love you. Ivan, you're amazing. 80 years old. That's amazing. Happy birthday. Happy birthday to Ivan's dad tomorrow. All right. Can we pay the damages in Shopkins? Apparently, that's going to be the next motion. It says, "Hi, Shapiro. Bettany Rage wrote this. It's got such a catty tone, and I can't help but hear and feel the keyboard getting pounded. Many computers, many laptops died in the creation of this document. The analysis starts with the actions of the doctors in the emergency room and intensive care unit. Where is the clear and convincing evidence that any of them had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to Maya would result, and despite that knowledge, intentionally pursued that course of conduct, resulting in injury or damage to Maya by falsely imprisoning her in these rooms? Keep in mind, there is no claim for punitive damages for medical negligence. If the jury believed that these doctors actually breached the standard of care by taking her off ketamine at the massive dosage she was receiving, when the doctor who had been doing this highly unorthodox treatment sent her to the hospital because it had failed, that is not a claim for false imprisonment. Where is the clear and convincing evidence that any of them were so reckless or wanting in care that it constituted a conscientious disregard or interference to the life, safety, or rights of Maya? They kept a child in the hospital when she needed hospital care and sought by her treating physician when her mother wanted to take her home. that was indifference to her life and safety by clear and convincing evidence. Her mother wanted to take her home. Her mother had the right to take her home. Her mother had the right to take her to another hospital or another doctor to get a different opinion. But instead, they kept her. Jacqueline says, recovered. You can't see me, but that $6,000 amount, my jaw dropped. Yeah, they lost a few zeros on that one. All right. There's no evidence that the officer director of this nonprofit corporation was involved in this. It wasn't managers. It was low-level people. We shouldn't be responsible for them. The defendant was entitled to a directed verdict on this claim. It was entitled to that relief on summary judgment at the end of the plaintiff's case. If this court does not grant a directed verdict, then the defendant is clearly entitled to a new trial because the manifest weight of the evidence does not support this verdict in the first phase of the trial for punitive damages. If we don't get a directed verdict, then we get a new trial. No, we're not even going to say that we want, that reduction, the whole reduction word. Motion for a new trial on the amount of punitive damages. Jury's award for this claim was $15 million. This is more than juries typically award as punitive damages for typically. This is the question. Does that mean some juries award more than $15 million? For a slow, painful death in a tobacco case. This award bears no relationship to the compensatory injury or the conduct of the doctors. It's patent demonstration that this jury, under the leadership of who? Juror number 1, and the arguments of plaintiff's counsel, was overwhelmed by improper passion and prejudice. This award, and all of the following awards, were prejudiced by this court's decision to try the unpleaded specific intent claim on the second phase of the trial and then emphasize it by placing it twice on the verdict form with alternative burdens of proof. There's no evidence that any of these board-certified pediatricians in a children's hospital had an intent to harm this little child. Why don't you call her ketamine girl here? Was that a typo? Much less specific intent, i.e. an intentional act performed for the specific purpose of harming the child. Those findings are once again clear proof this jury made repeated errors of great magnitude due to prejudice and passion. Mr. Opetorso says, recovery addict, I did the math for 6K versus 250 million. It's 0.0024%. Motions for remittiture on punitive damages. But if this court denies all of the preceding motions, which the defendant intends to appeal, stripped of its statutory immunity and faced only with the option of a multi-million-dollar judgment for punitive damages, then and only then, defendant would request a remittiture to no more than 3 times the appropriate amounts of compensatory damages. Thus, this huge award of punitive damages should be remitted to about $18,000. That's 16,000 times 3 for those who are struggling with the math. I did that in my head. Much easier numbers to think about and write on a checkbook, I'm sure, for the hospital. But $18,000 for which motion? Let's go back and see. Let's go back. Which one are we talking about here? This was way back. Yeah, this is the hospital stay. Is this the imprisonment? Yeah, that should be $18,000. That's what they say. $18,000 for the punitive on that side. So you're gonna have to round up, Mr. Opetorso, because we're clearly up to like 0.0075% now. I Hear for the Truth says, add the defense's settlement amount to the punitive damages just for good measure. Poor Judge Carroll, on his Thanksgiving break, had this to read. That's exciting. Let's see, Michelle Johnson says, Lawn Lumber, Rob, if you're in chat, will you consider going live tonight to summarize and discuss? Please, thank you. They're begging, Rob. They're begging. And we may have new documents tonight, Rob. That would be super exciting if these get filed here. Let me check the the docket one more time right now. Nope. I'm waiting for the. We might go live whenever it happens, but I'm waiting for the plaintiff's documents to drop. Ashley, there were so many people who were mentioned. Some of them just in passing. A lot of you, if you have not looked at the appendix, and I have not shown it because it has people's names all over in it. Okay, and I don't think that's right to do, but people you know and love in chat were wrapped up and included in screenshots. Names are all over there. You've got Emily D. Baker's name was included in there, and a screenshot of her account on Twitter, I think, as was Court TV. The Mr. Reyes, the company Mr. Reyes is from, the trial consultant, the technological consultant. They had all sorts of people. You've got the robot jury. The robot jury is in there. The entire robot jury wearing tags that says "this juror," this jury. That was crazy. Yes, we forgot we have multiple claims. Let's see what the hospital thinks is fair at 24,000 so far. So it's a little bit smaller. Remember, I thought they offered to settle for like 60,000. I'm not sure if that was just rumor or if that was true, but I heard that at one point they wanted to settle with the family for $60,000 over this whole thing. If somebody could confirm that, that would be great. Okay, keep in mind there's no claim for punitive damages. Let's see, we've got down here. There's the 18,000. Okay, the claim for false imprisonment involves the decision to move Maya down the hall from the room on the 7th floor where she was currently staying to another room that had video capabilities. We'll call it the dungeon room just for convenience. I know it's got EEG and things, but it didn't have EEG stuff in there. So let's call it the dungeon room. That way we all know what we're talking about. That room had the capability to allow for EEG testing, which played no role in the case at all. When in this room, it was a dungeon room with a view, though. You've got to say dungeon room with a view. When in this room, Maya was video recorded without her knowledge. This was done as a test to see if she would engage in activities that were consistent or inconsistent with CRPS when she was not aware that anyone was observing her. How is this treating a child medically? How is this providing medical treatment for a child? This decision was made by Dr. Paola Dees. Dr. Sally Smith also wanted this testing done for the DCF proceeding, although it ultimately played no role in that proceeding. So our doctor and Dr. Smith wanted her to do this, not to treat her, not to monitor a reaction for a treatment she's receiving, but to see if she was faking it. Let's move the toilet away from her and see if she's able to get up and walk to it. And then let's sit there and wait and watch. We'll all huddle around the monitor. I'd go back and watch on replay and analyze every motion she makes. Oh, she's applying lotion to her skin now. Clearly, this is all the proof we needed. The process was not actually treatment of Maya Kowalski. This process was not, we were not treating her at this time. Okay, she was complaining constantly of pain, but we weren't going to treat her. At this point, we were going to focus on the fact that we were going to catch her in a trap. Because, hey, she's a child and her parents aren't here and we can do this. It puts the lotion on the skin. Yes, it does. It was primarily a non-invasive diagnostic test. If Maya Kowalski engaged in actions completely inconsistent with CRPS, then that diagnosis could be rejected or at least highly questioned. If she did not, then CRPS would still be a possible diagnosis. The fact that they put, if she did something inconsistent, that was what they were looking for. This was their purpose. They were not looking for if she did not. If she just laid there in bed and cried, that's me like, dang, we didn't get anything. Might have to try it again. The doctors did not obtain a separate and specific consent of the parents to move the child to this room for the test, although a consent to photograph was obtained at admission. In retrospect, looking back, at least Mr. Kowalski could have been informed of this test. We might have been considerate of us just to tell him, hey, you've already signed over the right to photograph, so we're going to do it. If he made sure that no one told Maya, But it was in the child's best interest that she not know. But this was still not a treatment or an invasive test of the sort for which consent to perform the procedure often requires consent. This particular treatment or test didn't rise to the level where we have to get approval from the people who have the authority to make the decision. We can just do these sort of things on our own. As long as the dungeon room, the dungeon room with the view is used, it's okay. And especially if they don't know we're doing the test, then we can do that. The problem is they found out, apparently. That was the big flaw. But this child was rolled down the hall to this room, hopefully not roughly, just as she had been moved occasionally to other rooms. She claimed at the trial that she was imprisoned, but in the video recording she shows no signs of thinking she was imprisoned, other than the fact that she can't get out of bed without help, right? There's that little bit. Mary Kay gifted 5 memberships. Thank you so much, Mary Kay. That is super generous of you. Hope your holidays were fantastic, Mary. She shows no signs of thinking she was imprisoned. This child probably wanted to go home every day she was in the hospital. I'm betting you're right on that part. But that was a decision for the dependency court, not this defendant. Well, you made that decision before the dependency court made the decision to keep her. And that's part that you're on the hook for. The jury clearly did not review the video that is in evidence. Defendant files a brief index of locations on that videotape that show the child doing the normal things she did in any other room, leaving the room, sleeping, doing crafts, etc. The activities on this video are little different than her activities any other day in the hospital. So she sat in bed pretty much all the time and needed help doing everything. But the fact that she didn't crawl to the door and try to open it herself means that she didn't think she was imprisoned. Similar to the claim, this is renewed motion for directed verdict and motion for new trial based on the verdict against the manifest weight of the evidence. We're going to skip through this a little bit because this is a lot of the exact same thing. This is not a claim for invasion of privacy. Using videotape to help in diagnosis is not a false imprisonment at all. It could have been done in her previous room if it had a camera, which it didn't. This is not a claim for invasion of privacy by use of the video equipment. The recording was given to the parent's attorney within a month and not ever shown publicly by the defendant. They get this because we kept it secret. It shouldn't be a problem because we never released this publicly. We never released the pictures that we held her down and stripped her down to her underwear and took pictures of her. We didn't release those to the newspaper. So why are we getting assaulted and charged for this? Never shown publicly by the defendant. Only the plaintiff publicized parts of this video to the public, right? Because it was, okay. This court has ruled that the defendant has no immunity for performing this test, which had relevance to the DCF proceeding as well as to her diagnosis. But immunity aside, there simply was no disputed question of the fact to present to a jury as to whether moving this child to another room on the 7th floor for 2 days constituted false imprisonment. Even if the defendant is not entitled to a renewed directed verdict, the jury's verdict is clearly against the manifest weight of the evidence. Both the defendant's employees and the videotape itself very clearly provide more than manifest weight of evidence that no imprisonment occurred. She's a child who cannot move on her own, who cannot get up and walk out on her own. And because she stayed there and didn't yell and scream and throw things at the door and try to break out the window, they say that she was not imprisoned, so it should not count. Let's see. It shows that Maya thought that it shows no evidence that Maya thought she was any more imprisoned in this room than the room she was in the day or two before. She thought she was in prison the entire time. Admittedly, the entire hospitalization on the 7th floor may have been against her will, but the dependency court and not this defendant is responsible for that stay. The jury simply could not sort out the acts for which the defendant was possibly responsible from those for which it had total immunity. I'm thinking they did sort it out. False imprisonment, the jury awarded $1.4 million. Mr. Kowalski was awarded another $500,000. Jury awarded another $3 million in non-economic damages. Even a verdict of 1%, here we go. Even a verdict of 1% of this amount, $30,000, would be excessive. Under the law discussed earlier, it is not a verdict that can be used as any gauge to award a remittitor. It requires a new trial, not merely on the damages, but on the entire claim. Let's see, they asked for What number? Oh, here we go. Here we go. Where's the beginning? Way up here. But if stripped of its statutory immunity, as a last resort, if the only thing we can do is ask for a reduction in the amount, okay, the maximum lawful range for a future economic damages from these 2 days of hospitalization during which she did have nursing care and physical therapy as demonstrated by the plaintiff's evidence and did leave the room and sleep. She slept while she was in prison, so clearly it can't be that bad. As demonstrated, the video tape should be less than $5,000. That would be $4,999 or less. The past and future non-economic damages for an event that caused no physical injuries, just like dropping her on the floor, requiring treatment at the time, might somehow be worth another maybe $10,000 if the jury were allowed to speculate, wildly speculate. Throw in another $10,000. There's really no evidence to support the $1.4 million in future damages or the $500,000 awarded to Mr. Kowalski for this event. Yeah, about that. The plaintiff did not prove by any way to the evidence that this non-invasive test was performed at great risk of injury to the 10-year-old child, unless you count dropping her, if that happened at the same time, or that any bodily injury resulted from the 2-day stay in this room. Yeah, when did the drop occur? Is it important that it didn't happen in this transfer for the hospital? Where is the clear and convincing evidence that any of the members of the staff were so reckless or wanting in care that it constituted a conscious disregard for the indifference of the life, safety, or rights of Maya Kowalski? Could it be that the jury thought that when Maya was put there in that room with the commode away from her bed where she could not reach it, and the cameras were turned on, and she has expressed that there are some nurses she didn't like because they didn't come very quickly when she needed to use the bathroom. And so she had to use the bathroom just in bed, and they would get, some of the nurses would sort of short with her because of that. Could it be that all these pieces came together and that now looking back, she understands what happened or why they didn't come quickly and why they wanted to see if she would do something that she said she couldn't do? Could it be that the jury put these pieces together in their head when they heard all this evidence and it became very clear and convincing to them at that time that that's what was happening? The videotape demonstrates that her life, safety, and rights are little different in this room than in the room which she stayed before and after the test. The defendant is entitled to a directed verdict on this claim. It is also entitled to the relief on summary judgment and at the end of the plaintiff's case. If that evidence does exist, where is the evidence that a true managing agent, where's the manager? Committed any of the actions required for corporate liability for punitive damages for this claim. Apparently, we can only hold JHACH accountable if somebody who signs a paycheck commits the act. Anyone else is just an underling, and they don't have the authority to operate, in the name of JHACH. There's no evidence that an office or director of this nonprofit corporation, out of the goodness of our heart, was involved in this event. If this court decides not to grant the directed verdict on this unproven claim, the defendant still is entitled to a new trial because the manifest weight of the evidence does not support this verdict in the first phase of the trial for punitive damages. Ooh, look at that. It tipped. I've never seen I could do that before. Whoa. Yeah. Is that cool, or are you guys just getting dizzy? I'm sorry. I didn't know I could do that. I just discovered a new feature. So they want the dropped here. Here for the truth says, I changed my mind, RA. Add the amounts defense wants to settle for to the compensatory damages. Insurance doesn't cover, correct? Add the amount defense wants to settle for to compensatory damages. Insurance doesn't cover, correct? Yeah, I think you're correct on that. It's a drunk PDF. Sorry, it's been a long morning, and I'm excited to be here again. I'm one of those bus stop people getting excited about rotating pages. All right, let's see what we have next. Here they say for this one, hang on. On punitive damages, if this court denies all the preceding motions, which the defendant intends to appeal, stripped of its statutory immunity, and faced with they repeat these lines over and over. If held at gunpoint, then we will agree to let the judge reduce this amount to no more than 3 times the appropriate of compensatory damages, and that would be $45,000. This multi-million-dollar award should be remitted to no more than $45,000. The claim for false imprisonment. Let's see. They say they have immunity. This claim involves Maya Kowalski's testimony that she was placed in a room for a few minutes and photographed in her shorts and bra prior to being released from the hospital to go to court to see Dr. Duncan and Dr. Hanna on the day of the hearing, following which Beata Kowalski wrote her suicide notes. Plaintiff claims that she was stripped naked in this process, but no such photographs exist, and the two hospital employees deny that any such stripping took place. There are admittedly two very different versions of this event presented by the evidence. Yeah. Our two people, I think, don't agree entirely on what happened. And our two people also can't say whose hands are in the picture. Or won't say. Can't or won't. I'm not sure which is the case. But there's a hand on Maya Kowalski that the skin tone does not match the nurse. And seems to match one of the other people that was in the room, whoever that was, maybe Kathy Beatty. Seems to be a match. Yes, and I actually did take pictures. I did take pictures and overlay the two hands together. They seem to be a match. The vein structure, the location, the scars, everything seems to be a match with Kathy Beatty. But Kathy Beatty has no idea whose hand that could possibly be, because I think if her hand was on Maya, that would definitely constitute battery in my mind, especially in that setting. All right. Let's see. Assuming Maya recalled this correctly. At age almost 18, of the event she had occurred when she had just turned 11. The event lasted a short period of time. She was in a hospital bed that in some of the pictures has images of her stuffed animals. Clearly, there's Shopkins there. How bad could it have been? She appears to be upset at this procedure, but there's no evidence in the photographs that she was struggling. We don't see any motion. Okay, it looks like she's holding still in the pictures. If you look at, according to the hospital, if you look at the pictures, it looks like Maya's holding still, which means she's tolerating it quite well, right? Apparently she holds still in all photographs. There was no evidence that she was tied to the bed or physically restrained by holding her head or feet or other parts of her body, other than the fact that earlier in this document, you say she was held on the bed. There's that. Let's see. Let's do, what page are we on right now? Let's do a quick check. We're on page 66. Let's do a quick little find and say held. And see where. Why won't it let me search? I want to find that little part. Find. For some reason, it doesn't view the whole document. It only views this timestamp on the end as Word, so I can't search this way. So I'll have to switch to another reader. Let's see. Grant the same motions for each of the punitive damages. The 3 subclaims for false imprisonment, 1 subclaim battery, for which the jury returned a bifurcated verdict later in the day, awarding $50 million. This motion is unavoidably lengthy. Wait, how did I end up at the top again? I was on page 66, wasn't I? Let's go down here. This is where it's lengthy, but we don't want to reread the whole thing. If Maya told the truth, she has pictures of her stuffed animals. She appears to be upset, but there's no evidence that she was struggling. There's no evidence she was tied to the bed, like no ropes or chains. This was not the dungeon room, not like the dungeon room that has the ropes and the chains. And there's no evidence there. There's no evidence this photographing required more than the assistance of a nurse while Miss Beatty took photographs, other than the fact that the 2 people who were there can't say who the third person's hand is. Just saying, just leaving that out there. The notion that Miss Beatty was simultaneously photographing Maya Kowalski while holding her down with her hands that did not even seem to have the same complexion as Miss Beatty. Really? Is not testimony. They have not seen my video. Mr. Shapiro, if we can talk just for a minute. I know you're watching this. I've got a video for you to watch. You can even show it in court. It would be great. Go ahead and write it up. I took every time that Kathy Beatty raised her hand in her deposition, and it was held at the same angle relative to the camera as the picture in the Maya Kowalski photograph in the hospital bed moment. I matched them up, and I overlaid them so you can see the similarities. And you're going to see that although we've had experts already take this and color grade it and match them precisely based on the different lighting and the different scenarios. I didn't even do that. I just overlaid them. I'm just telling you. You might want to cut this part out, Mr. Shapiro. I think this is not your strongest argument. It is not testimony that is credible, nor is the testimony that the photograph in which the sun is shining brightly through the window was taken on her return to the hospital that evening in January when the sun would have indisputably have been down. The testimony of her uncle concerning her behavior shortly after this event does not support a claim that it caused her great distress at the time. She did not report to her psychologist that day or to the family lawyers. It's funny how people can get injured or, and not say anything immediately when they're not bleeding. Call the son to testify, says Greeners. Kowalskis were claiming that certain scratches or other marks on Maya Kowalski's body were CRPS lesions. The defendant's doctor did not interpret these marks as lesions and believed the marks, especially the scratch on the forehead, may have been a scratch by Maya Kowalski herself. The photographs were taken to document her skin condition at the beginning of the day and at the end of the day. The defendant has not claimed the evidence for this event entitled it to a directed verdict on false imprisonment. So tell me, did you find a difference? Or did the lesions stay the same from the beginning to the end? I think they did. Oh, man. The manifest weight of the evidence does not support the claim as described by the plaintiff, but false imprisonment is a tort involving an intent merely to perform an act that is unreasonable and unwarranted. The defendant believes that under all the circumstances, photographing Maya Kowalski on January 6 was not unreasonable or unwarranted, but is not contending that it obtained the parents' express consent. Well, there's that small thing. Yeah, we forgot to ask the people that have the right to say no. Or that a reasonable 10-year-old child could not find this conduct offensive. Maybe Maya could have said, I'm not really happy about that. And thus the jury could conclude this event was unreasonable and unwarranted. An unreasonable jury of 6 bus stop people might conclude that. It requests a new trial on liability because the evidence that the Kowalskis signed the release form on admission for allowing. We need a new trial because they signed the form, guys. They signed the form allowing for photographs. Yes, this is the case number. If you're doing the search on the Sarasota County clerk, Sarasota clerk page, every time there's a hyphen, put a space in there, and that works the best for me. So 2018 space CA space 005321 space NC, and that's how it searches. Nurse for God just gifted 5 memberships. Thank you very much, Nurse for God. Very generous supporter. Okay, so this issue is either involving the manifest weight of the evidence or an error by the law of this court, by this court. The only way this court cannot grant a new trial, the only way, Judge, the only thing you can do, and I'm sure the judge loves this when lawyers say, Your Honor, you have one option. The only thing you can do, cannot grant a new trial is if it determines the release at admission was unenforceable as a matter of law. But for this false imprisonment in a hospital room for less than an hour, the jury awarded Maya $188,000. Math is hard, guys. $188,000 for medical care and psychological expenses in the future. There's no evidence in the record that this event required medical treatment or psychological treatment even in the past. There's no evidence of any bodily injury from this event that required any medical treatment. There's no evidence of medical bills paid for any such treatment. But the jury ignored the evidence and instruction to address this claim as a separate claim. It awarded Mr. Kowalski an additional $325,000 in past medical expenses for the care of injuries caused by this event. This jury awarded Maya another $15 million in non-economic damages for this event. and for an event that did not involve any of the usual facts of a false imprisonment. The usual facts where a person is locked in a room, intentionally tied up and tortured. Oh, we forgot those things as well. We forgot to tie her up and torture her. So it should not qualify as the usual type of imprisonment. This is the third example of an award of pain and suffering by this jury that exceeds the bounds of any reasonable range in which the jury could possibly operate. A verdict of 0.5% of this amount, $75,000, would seem high. Seems a little much, but be closer to the correct amount. A verdict of 1%, $150,000, would reach or exceed the maximum limit of a reasonable range. Okay, and this is another verdict where the jury was overwhelmed by passion and prejudice. Under the law discussed earlier, this is not a verdict that can be used as any gauge to award a remittiture. It requires a new trial, not merely on the damages, but on the entire claim. Seems a little high. Defendant submits that the maximum lawful range for future economic damages from this event would be less than $50,000. It's a cheap one. Let's see. Caused her to have PTSD. There's no evidence this short event caused or was a substantial contributing factor to PTSD. This one thing that she hated and didn't want to do, and even though we knew that she was very private, that Maya was very private, even so much that when she had to change in her hospital room, even though she's in her own private hospital room, she would have a nurse hold up a sheet, like so that she could be behind the sheet to change because she had to change in bed. And then after she was changed, then the nurse could put the sheet down. We knew that she was that private, and the fact that after knowing that, we took her into the hospital and then brought in this lady who she hates, okay, and let her take photographs of her half naked. That's not PTSD. That couldn't have been the cause. As to non-economic damages, the maximum lawful range for these damages from this event would be no more than $150,000. This is the big one according to the hospital. This is their big mistake. Their big mistake was these photographs. Apparently, they're willing to pony up to the tune of $150,000. Where is the clear and convincing evidence that any of the defendant's employees were so reckless or wanting? Any of the defendant's employees, right? Because who's not an employee? Were so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of Maya Kowalski. And where is the evidence that they photographed this child with a specific intent to harm her? The photographs were taken to document a questionable appearance of lesions on her body. Oh, now they were taken to document the questionable appearance of lesions. And they were taken because she was required to leave the hospital under court order. So if they were taken to document a medical condition, lesions on her body, why are they not in the medical file? If that evidence does exist, where's the evidence that a true managing agent committed any of the actions required for corporate liability for punitive damages for this claim? The fact that it has to be a manager for corporate liability for punitive damages to this claim means that the MedMal laws in Florida need to change. That it has to be a manager that does something for a corporation to be liable. There's no evidence that an officer or director of this nonprofit corporation was involved in this event. Other than those file notes, you've got that pesky risk management. Those management. I said the management word. Risk management notes. No court order photographs. Let's see. Okay, where are we at? I think we're going to wrap things up here soon. Let's see. Jury awarded $25 million here in this case. This must be the most clear-cut example that this jury, under the leadership of juror number 1, they gave him that number for a reason, and the arguments of the plaintiff's counsel were overwhelmed by improper passion and prejudice, and this belief in the defendant's employees had a specific intent to harm this child. I really think that juror number 1 was chosen first. That everyone else was eliminated for various reasons, but juror number 1 was the first juror that the defense thought, nah, he's good. We'll go with him. Let's see. multi-million-dollar judgment. They think that punitive damages for Maya must be capped at a total of $500,000 if this court were to somehow conclude that it had authority to award an amount in excess of $500,000. Now they're up to $500,000. New trial on excessive compensatory damages. Maya got $4 million. Mr. Kowalski got another $500,000. Jury awarded $8 million non-economic damages. We think that less than 0.5% in this amount, or $25,000, would be closer to the correct amount, or a verdict of over $50,000 would clearly exceed the range which the jury was free to operate. Did they just not know? Did the hospital just not know that it could end this way? Did they think they were limited to 1 comma? It's like the jury, you're allowed 1 comma in your damages. Place it where you will, but you get 1 comma. These employees were not taking photos to put on the internet. They were documenting the child's skin condition. Hang on. These employees were not taking photos to put on the internet. They were documenting the child's skin condition before and after a trip to court. This event did not cause a bodily injury that required any medical attention. Is that the only type of injury that exists? Is a bodily injury? Or can there be emotional scars? Can there be mental injury? There's no evidence of even a bruise. We held her most gently, except for when we dropped her. There's no evidence Mr. Kowalski insisted that Maya have psychological therapy for this event, or that she has had anything other than minimal psychological counseling needed to place an expert witness on the stand in this trial. Could it be, JHACH attorneys, could it be that Maya does not want to go to a counselor because all her medical records are subpoenaed, and anything she says, even to a therapist, becomes fair game for your attorneys? Is that possible? Whereas the clear and convincing evidence that any of the defense employees were so reckless or wanting in care that it constituted a conscious disregard for indifference of life, safety, or rights of Maya Kowalski. And where is there any evidence of any sort that they touched Maya Kowalski to obtain these photographs with specific intent to harm this child? I'd say in the pictures. In the pictures. Look at the pictures. You must be looking at the back of the picture. Look at the front of the picture. That's where I think the evidence is. All right. Now they say motion for new trial. If we don't get that, then go ahead and reduce the damages. Battery for hugs and other touches. Battery for hugs. It's like the Energizer Bunny. Battery for hugs. Maya testified that in chapel and at other times, Catherine Beatty gave her unwanted affection, including hugs, at least 1 kiss, and sat on her lap. She sat on her lap. The Maya, the 10-year-old girl who has trouble moving, just climbed right up there. She claimed other touches that were painful. This claim only involves alleged batteries by Miss Beatty, and it does not involve a claim arising to the level allowing for punitive damages. It doesn't mean enough, I guess. It wasn't bad enough. Miss Beatty testified that she did sometimes give Maya Kowalski affection when she thought the child needed affection, and that she believed it was professional to do so on those limited occasions. She claimed she held Maya Kowalski on her lap after the child was very upset that the dependency court did not allow her to go home for Christmas. Whose fault was that? There is no evidence that Miss Beatty spanked this child for any reason. She didn't spank her, at least. There's no evidence that she slapped her, whether for discipline or out of anger. What if was there a medical slap? I mean, what did we leave out? Did she slap her legs to see if there was a reaction? Maya Kowalski, at least by today, clearly does not like Miss Beatty. At least by today. She was the face of Johns Hopkins Children's Hospital for Maya Kowalski because she was the most experienced social worker that dealt with children in DCF custody. She was the bearer of bad news whenever there was bad news to deliver. It is understandable that a child would not like Miss Beatty, even though Maya appeared to like many other members of the staff. Could it be bad enough that she has PTSD about it? And when that person who she has PTSD over takes pictures of her half naked, that becomes a major issue? There's no evidence that Maya Kowalski received any medical treatment, in the past for these touches. There's no evidence that these touches were a substantial factor in any PTSD from which Maya Kowalski may suffer. There's no claim that these touches aggravated a pre-existing condition, and no such jury instruction was given. For these alleged batteries, the jury awarded a total of $19 million in compensatory damages to Maya Kowalski and $1,000 to her father. The compensatory award included $8 million for economic damages in the future and $11 million for non-economic damages. It is the defense.
Taking it easy.
Judy, thank you very much. Thank you. Let's see. It is the defendant's. I'm missing chat, so I apologize. It's the defendant's position that even Maya Kowalski's version of these events creates no question for a jury on whether a reasonable person would find these touches were offensive under like circumstances. So even Maya Kowalski's version of these events creates no question for a jury on whether a reasonable person would find these touches were offensive under like circumstances. That is the test for legal battery. So the lady who's responsible for your mom not being able to see you and for you not being able to go home, if she kisses you, pats you on the head, sets you on her lap,
When are we going to break for lunch?
and tells you that she can be your mom, no other person under those would be the like circumstances. No one else would find those offensive. Is that what they're saying here? The defendant realizes that reasonableness is typically a jury question. So maybe this could go to the jury. But the circumstances here involve a child who cannot receive physical affection from one parent and only occasionally can from her father or brother. Why is that? The plaintiff claims that this child needed an advocate in the hospital, but when a trained social worker believed the child needed comforting, the plaintiff claims the acts of affection and comfort were something a reasonable person would find offensive. And they did. Respectively, a reasonable person would find it offensive for a social worker not to give some affection to a child in this context. How could she not? Kathy did the only thing that any reasonable person would do. Is this before photographing her naked or after? When she pats her on the head and gives her a kiss and hugs and tells her that she could be her mom. I'm confused about the timeline. Somebody straighten me out. A female social worker placing a child on her lap when the child is upset does not rise to the level of battery. Maya Kowalski claims that Mrs. Beatty told her that she wanted to be her mother, assuming that testimony is true and Miss Beatty's testimony is false. Okay, I'm with you. That statement is not a battery, and it did not involve a touching. It would have to rise to the level of extreme and outrageous conduct intended to cause Maya Kowalski severe emotional distress, even to be relevant in this case. Okay, I'm still with you. Accordingly, the defendant was entitled to a directed verdict on this claim at the end of the plaintiff's case. The defendant's right to receive a directed verdict is even more obvious now that all the evidence has been heard. Yinzi, I think you're right. Ask Mr. Shapiro how many strangers are allowed to touch his children. Man. All right, here's what we're going to do. We're going to scroll down and see what their end statement is here. Even described as by Maya, these touches are not batteries. They are not touches that would be offensive to a reasonable person. This claim is admittedly a claim based on the testimony of two people, a child that wanted to go home from the hospital and now seeks millions of dollars in compensation, and a social worker who was dropped from the lawsuit immediately before trial without a monetary settlement. The child has relived these events over and over in her mind, in part because her father's lawsuit has required her to do that. Between the two, the weight of the evidence does not support the plaintiff's claim. They say, let's see, what's the amount they say? Nothing. Oh, here we go. A verdict on both economic and non-economic damages of less than 0.5% of this amount, $85,000, would still far exceed the range in which the jury was free to operate. Okay, let's see if we can find the final math. Future damages would be less than $10,000. There's no evidence of this would cause PTSD, other than the fact that there was evidence that it caused PTSD. Talk about how she wasn't able to work at her job because she saw someone that even looked like Kathy. Less than $25,000. Emotional distress, this is a big one. Let's scroll down to the bottom here and see where we're. Renewed motion for breach of duty, causation of damage. Let's see where we are. Okay.
There's a lawsuit.
It's a big lawsuit. Motion for new trial based on the legal error of allowing this case to contain a negligent training count to the very end when that count should have been resolved no later than the motion for summary judgment. It was taken under advisement at that time. I think the judge didn't do anything wrong.
I'm not a cat.
I'm not a cat. Lower, lower, lower. Issues affecting the claims presented by the state. I want to see their final. It's going to be right at the very end here. What's their summation? That's 142. Okay, here we go. Let's go back. Conclusion. The defendant realizes that this is a long set of motions. We realize that now as well. But factually, there are 10 overlapping claims, including the 3 false imprisonment claims and the 2 battery claims and the 2 claims for intentional infliction by the estate. Including punitive damages, the entire verdict exceeds $260 million. These motions address a verdict for $250 million for claims that raise serious questions about whether they even should have been submitted to the jury. They address what appears to be the first ever trial of intentional infliction of emotional distress causing a suicide. That's true. And it is a claim by the estate of a woman who had not been in the hospital for almost 3 months, was never a patient, and had almost exclusively indirect contact with hospital employees. A case where the suicide occurred after the events in a court proceeding for which the state and DCF are protected by sovereign immunity. These motions have merit, and they warrant full consideration. Signed who? Mr. Altenburn. Mr. Altenburn. And he sent it to everybody. Sent it to everybody.
Alex stole it.
I want to see the number. Thus, the defendant submits that the highest award under order of remitture should not exceed $6 million. They want it to be reduced to $6 million. That's their final offer, right there. But only if the judge, orders that, and then they're still going to appeal.
When are we going to break for lunch?
We're going to break for lunch right now. All right, so this is the end. There are a couple other little bits here. Let's see. Appendix A is has to do with the calculations for the closing from the plaintiff. See, they have the breakdown of the video clips for the recording. That's Appendix B. And then C was a bill for treatment on June 16th, 17th, 2015, prior to the October hospitalization. There are examples of bills that contain diagnostic code numbers, that is the code for CRPS, among many other codes. The charges include charges for days in the hospital and the ICU and items that were presumably covered by other codes, as explained in testimony. Without further testimony, the bills do not provide proof of any material misrepresentation. All right. So there we go. No breaks, double shifts, says Butch Jones. No, we're done. We're done. Here's what we're going to do. We're going to go back and see if the court has filed anything else. We're waiting for the response by the plaintiff. And we do not have it yet. We do have a motion on December 15th at 8:30 a.m. in courtroom 6C to address these motions. Presumably all of the ones that are filed between now and then. That's our next hearing. And that's all. The response to this will be great. I think it will. We're getting dumber by the paragraph. 80s Music Man, the frustrating thing about this is a lot of it is copy and paste. the process of writing these motions, a lot of the argument is repetitive, and so we just get the same thing over and over, and they say it 6 different times. I still want the answers to what happened with the rest of the ECG video. It must show that just awful treatment has just disappeared. So we're missing a couple hours, right, out of that. There's another filing regarding juror number 1 that popped up today. Where are you seeing that filing, Trish Francis? And I apologize, you've got like a whole minute to wait to respond. Are you seeing it under the same case? Do you see the disgraceful addendum to that filing all about juror number 1? I saw the let's see the appendixes. I've got the motion for the new trial, juror interview, and open discovery, preserve evidence. And then you've got those 3 exhibits. But I haven't seen anything other than that. What if there's something else out there? Oh, you are in the motion for yes. So we made the motion a little apparently. Megan has access to a couple things that have not been posted yet. She's got a great relationship with the defense team, so she's been given permission to share some things before they show up in the docket. These motions were expected, people, for real. But even though they're expected motions, the language inside, the absurdity that some of them reach to was not expected. They put first and last names in an article of juror number 1. Kiri, thanks for clicking the subscribe button. We call that admitting to being a true crime addict. Thank you very much. Welcome. Like I said earlier, there's a 5-page bundle. It may show up tonight. It may show up tonight, and if it does, we might see if we can go live. This was a motion for a directed verdict. It was renewing a motion for a directed verdict. It was also mostly a motion for a new trial, which I think is what they'd like more than a directed verdict. But if the judge won't, I guess they want it in this order. They want the judge to reverse everything that the jury did, which typically would be called at this point a judgment notwithstanding verdict, or a JNOV. So the judge reverses the verdict at this point, and instead of where the jurors marked yes, the hospital's liable, the judge would scribble that out, cross it out, white out, whatever, and mark no, and then sign Judge Carroll. That's what they want on all these charges, on every single one of them. If they don't get that, they say, if we don't get that on all the charges we don't get it on, we want a new trial. And if we don't get a new trial on all those ones that we didn't get the JNOV on as well, we would like the amount reduced, typically to like 1/2 of 1% of what was offered, or 1% of what was offered, somewhere way lower than what was in there. So those are the 3 things they want in that order. Finding appeals isn't a temper tantrum. It's called the process. Right. It is the process. It's expected. If they didn't file these motions, they would not be doing their job. But the wording in the motions and the logical or illogical, as the case may be, arguments is a new level, I think. Juror number 1's going to make some money now on a book deal. The defense is going to make him famous. Okay, Sherry, I hate that they're digging into this. They brought up an issue with juror number 1's wife. There may have been a family law situation where there was a lawyer in that hearing or in that proceeding that was the same as a witness in this trial. And they're saying that because juror number 1 didn't say I know that lawyer, that's a problem. I don't think that's a problem at all. If you look at the facts of what was going down, I don't think there's any reason for him to say he knew that lawyer or for him to know that lawyer. What do you use to find the latest motions to and from the court when it comes to this case? Is there a website? P-Will for real, yes, there is. If you go to sarasotaclerk.com, there's a search. There's a website there. You have to sort of either log in, which is a sort of a pain in the butt, or continue as a guest, and then you have to understand how the search works. The search field is very, very picky about what you put in, and if you were searching for files on this particular case, I'm going to put it in chat right here. This particular case is right here. That's what we would put in the search field. And that shows that it's a 2018 case. That's when it was filed. CA, it's a civil action. It's not a criminal. That would be a CR. And then the case number is 005312. And then NC, I'm not sure what NC indicates. We should get the plaintiff response in the next hour. It's going to happen soon. We might take a break here and then see if it happens. I'll run and return my TVs. Let's see. Honestly says the newest motions regarding juror number 1, how he had a DCF complaint against him in 2002, and it's going to be bogus once you read it. Yeah, they're literally throwing everything they can at the wall. NC non-criminal. Yeah, the other case they're referring to is under seal. It's not something publicly available, but you can read between the lines on some things, and specifically just the dates and times are what I was talking about. Megan, thank you very much. We were shouting your praises earlier. You've got a connection. Let me take a quick peek at this. Let's see if it'll let me. See if I can send this to my. So if you have not watched Megan and Legal Vices, and you have more information or questions about, or you need more information, you have questions about the document we covered today, they covered it first and did so with a great job. Did a great job picking out some of the most absurd things in that document. Can you throw us over to the lawyer? You know, is he live right now? We can do that because I've got to go to Best Buy and return these TVs that I thought I was getting a deal and I bought the wrong ones. Let's see. I do see him. He is live. Okay. Let's do that. Let me bounce you over there. I'm not sure how much longer he's going to go, but let's wrap this up because I've got to run an errand and then we want to watch these documents. Megan, thank you very much. Megan sent me this document that you're talking about. And I want to review that for sure. I want to review it first, and we might go live later tonight with it. Thank you, Megan. Appreciate you. Would Judge Carroll be holding the hearings? I believe so. It's a different courtroom, though, so I'm not sure. It's in 6C. Might be getting to the point where it's just cheaper to pay the settlements. It is. Megan will have to do a reading sometime. I do like reading. I'll need some water before then, though. I did all this without water, and I'm parched. Okay, there's the. Oops. Sorry. I made a mess of everything. Show chat. Pop out chat. Too many windows. I clicked on the link. Samantha Terry, there we go. there's the link if you want to follow this and watch for updates. Use that code that I gave you earlier. Hopefully you've saved it somewhere, and that'll help you on the search. But if we don't get any new documents, or if I'm not able to go live with this tonight, depending on what happens, what the line is at Best Buy, so tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. We're planning on tomorrow. We are looking to have a new court start. Realize this is sort of like a holiday extension week, so not a lot of there's your promo code. Yes. We're not a lot of new cases happening right now, but if you see something coming up that you think that we should follow, go ahead and give us a shout out on the burner phone. I say us, that's me. I'd love to take a look at the cases that you're interested in and see if there's somewhere we can match up and get some coverage for you. Thank you, everyone. Appreciate you being here. Thanks to all of you. You're amazing. Thanks to the great mods. Have a good night. We'll see you a little bit later. Bye-bye.